The Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone, and welcome to the Appeals Court. I am Chief Justice Amy Blake. Today, I am joined on the panel with Justice Christopher Hodgens and Justice Robert Toone. We are your panel for the 6 cases that we will be hearing today. As a brief introduction, I know most of you have been here before. Each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all of your papers, so you should get right to your arguments. We will likely hear the first 3 cases and then take a brief morning break and resume to hear the balance of the list. To the extent that any of the cases are impounded, I will remind you as we go, but please be mindful of that fact. With that, we will call the first case, MARSHA CHERY versus DIONY REJOUIS. I'm sorry if I've mispronounced that. Docket number 24P361. Counsel, good morning.
Good morning. May it please the court, my name is Chris Nishaw. I represent the appellant, MARSHA CHERY. Keeping in mind, as Your Honor had mentioned from reading the briefs, I think my argument essentially is pretty short and sweet. The most important one for my client being the issue of the modification of the judgment regarding parenting time specifically is the erroneous issue. I know in the brief it mentions the legal custody, physical custody, those matters, but I think the main issue for my client...
You're not waiving that argument, are you?
No, okay. I'm not. But I think that in focusing my time, the most important thing to bring initially is that issue of parenting time, because there was a judgment that clearly stated, excuse me, I'm getting over a cold. There was a judgment that clearly stated that there was an agreement by the parties, clearly intentional of a parenting time to take place and increase thereafter, as it says in the judgment, in light of the COVID crisis. You then have facts afterwards that are on the record that the judge acknowledges that the father himself was adjudicated as repeatedly and intentionally being in contempt of that up through April 6th.
And the contempts aren't before us, right? Just the mod judgment?
No, the contempts are not before you, Your Honor.
Actually, can I ask you a question about that? And I promise you I'm not trying to be difficult. And I recognize that you were not the attorney at the time. But your brother counsel has raised an issue, and I've looked at the notice of appeal, and does it comply with the rules?
Well,
we don't know what she's appealed. It just says we've completed our obligation, she's getting new counsel, and please enter her notice of appeal. The rules are pretty clear about putting opposing counsel and us on notice, and I understand it looks like perhaps she was self-represented at some period of time, but it's tricky.
I can only, I would, as you said, I was not the attorney of record prior hand. I can only state that I think in light of what has been presented by this office, it's pretty clear what is being appealed to that issue. The contempts are not, I mean, the briefs mentioned specifically that the contempts not being of an issue, and the parenting time, the custody being the specific judgment itself that was being appealed. So
if we go to the merits let's move past what might be a deficiency in the notice of appeal, and we go to the merits. Part of your argument seems to me to be a challenge to the way that Judge Cronin weighed the credibility of the witnesses, that in some respects he didn't believe or credit your client, and he credited the dad. How is that reviewable by us on appeal unless it's clearly erroneous, and you really haven't made that argument? So aren't we sort of handcuffed by the judge's credibility determinations for purposes of what becomes the judgment?
To the credibility issues, yes, I still think there's an erroneous issue here in light of...
And what do you say is clearly erroneous?
Well, as I mentioned, the judges themselves admitted in their record that they had already found the father to be in contempt and had been denying parenting time for this mother up through the April 6, 2022 decision finding that specific fact. And then we have, going forward, a year later, in May, we have the issues of the trial, where essentially the facts that are facts that are found by the court in that instance, in light of the credibility issues that are being said, that essentially there's not parenting time because of a dispute between these parties. That's the essential, that's brought up multiple times repeatedly, is saying that because the parties can't agree on parenting time, because the parties haven't been able to do the parenting time, mother has not seen the child. And I think that the error is that in a complaint for modification, obviously substantial change in circumstances, the judgment itself is saying, okay, well, mother has failed to argue a substantial change in circumstances as to regards this for me to modify the prior judgment in which she's supposed to have parenting time, and has said, okay, well, you have not met that burden. Father likewise has a counterclaim for a modification. There's not really anything mentioned in there as to meeting that burden, and then as a result, mother is completely stripped of all parenting time, even though it's clearly recognized that father's contemptuous failure to allow her to see the kid is acknowledged by the court in this matter. So that's the main error of law that, or the main error, that erroneous decision making that I would say that the court has found. Like, we have this decision going on describing how the parties, excuse me, how the parties from the judgment, what parenting time there was or was not as a result of a dispute between the parties. There's never any talk in this judgment itself or the rationale about mother's failure to do this, mother's failure to do that. It just says the parties can't agree. The parties can't, there hasn't been parenting time because of the dispute between the parties. And at the end of the day, the sole remedy and the sole issue that gets is addressed and resolved is mother now has to solely take it upon herself to have psychotherapy with this child, despite the fact that the court found previously that part, if not solely, the reason that the child had not been seeing the mother is because of the repeatedly and intentional action by the father to not allow her to see the child. And that's the main issue for the outcome of the case. I don't think that this is not, more as a complex as some appeals, and so I think, the main issue that has been brought is, for my client, is that legal custody was already adjudicated and ruled on by a judge. So that judgment existed prior. She would have the same obligation to show a substantial change in circumstances, why that has or has not occurred. I think the decision in that matter addresses that issue. Likewise with the custody, because there was a custody judgment already in which the father was the primary physical custodian. The appeal does not, yes.
Are you saying that she should not have had to have shown a substantial change in circumstances, or that she did make such a showing? I'm not sure what your argument is.
No, the burden would be on her as the plaintiff to show a substantial change in circumstances.
Okay.
I'm not arguing that.
You're not arguing that. So you're arguing that she did do that, and the judge incorrectly determined that she had.
Yes. Okay. And then one of the things that was mentioned in my brief is that it has been found in prior courts that the conduct of someone not allowing the child to be seen by the other parent is a substantial change in circumstances. It has been found to be that in the past. So here we have an adjudication during the pendency of this matter where this judge has decided, yes, father has been intentional and repeated in not allowing her to have her parenting time pursuant to this judgment. Then in the final judgment itself is, well, they have a dispute. They have a dispute. They can't agree on parenting time, and I think that's erroneous to the extent of the outcome being she has to now go do psychotherapy with this child in order to have any parental rights whatsoever now.
What do we do about the GAL report that came in by agreement without testimony? And that piece of the case is impounded, so I'm going to be careful. And thank you for making that happen at the late hour of getting that to us, both counsel. But there's some pretty significant findings by the GAL that the court adopts that no one has suggested is clearly erroneous about the relationship between the mother and the child. And then I put that into the backdrop of the child's special needs. And while I appreciate that there has been some findings about what dad has perhaps not done to help this relationship, in the broader context, there's a lot more going on here. This child does not know his mom at all and wouldn't even attend the meeting with the GAL without some promises of safety and support. So that came in uncontested. That's pretty significant.
I cannot disagree with that. In reviewing the record as part of this appeal, I was from the plaintiff's side in that case, and now the appellant side. It was interesting to me to see that the GAL report was just mentioned one time as it's going to be evidence, and that's that. So the GAL was not cross-examined as you're mentioning. So I'm kind of, as you were mentioning earlier about your own restrictions, I'm kind of handcuffed by the extent that the GAL report was admitted as evidence. The judge took it into consideration. Excuse me. I do think the judge, has the discretion, obviously, to find the facts that he or she may do from reading and interpreting a GAL report. So as part of the appeal, you'll notice there was nothing mentioned about the GAL report being erroneous or that the judge utilizing it in the manner that he did was erroneous. But I would point out that the child was 7 at the time of this occurring. And again, going back, and I can't put myself into the mindset of the judge in that instance, but a 7-year-old kid who has not seen a person, relative, parent, whatever, for a long time, it's more than reasonable that they're going to be feeling that way. And the fact that the father directly and intentionally contributed to that, I don't think is addressed in any way, shape, or form.
I certainly understand why your client has appealed. I get that as a human being. I do understand that. But, we have upheld decisions where a trial court judge, for different reasons, has suspended all parenting time indefinitely. Or I believe there's a case at Rosencrantz maybe for a year. So here, yes, the ball's in your client's court, but with the judge ordered reunification therapy. The door is not closed, but it's hers to open. So I don't know if she's watching on the live stream. I don't know what the result of this appeal is going to be, but the one sort of silver lining here is that there is a door for her to open to get back into this child's life.
Yes, it wasn't terminated perpetually or even temporarily, but as a practitioner, the idea of having to do that is it's not as easy as it sounds to do. But that being said, is the judgment itself that is being modified was that she is supposed to have parenting time.
Right.
And she's supposed to, and we went from that to, and keep it in mind, the father's counterclaim for modification as well, and that modification now.
Well, he was looking for supervised parenting time.
Supervised parenting time, yes.
And ultimately, the judge said, no, I'm going to suspend it and start reunification therapy.
Correct.
That's where we are.
Yeah. So
has that happened? Has she started? I know that's outside the record, but.
She has not, and the issue being largely, again, the ability to do so. It's not like you go to the store and it's not as easy to find a psychotherapist for juvenile reunification therapy as one may make it seem. But that being said, that's the judgment. So you're right. That is what her hurdle now is to do so, and that's the issue she's having, and that's why she's raising the appeal. So unless there's any specific questions, I think.
Yeah, I just have one question, just to clarify. So are you saying that the judge should not have addressed the mom's parenting time on the complaint for modification or on the counterclaim, or that the judge abused her discretion in how she addressed it?
I would say it's an abuse of discretion of the facts. In light of the record that's put on, or at least what's mentioned in the decision as to what was relied upon to make, I believe is yes, the abuse of discretion. Yes.
Okay. Thank you.
I don't see any other questions. Thank you so much.
Thank you, Your Honor.
Attorney Cantor?
Good morning, Your Honors. Andrew Cantor for the appellee, DIONY, REJOUIS, who I may refer to as father. Let me put aside the prepared argument and respond to a couple of things that the Chief Justice had raised to my brother counsel. The first is, if the court wanted to dismiss this on a jurisdictional ground, I think it could do so. The Chief Justice had asked about the notice of appeal, and to be clear, the notice of appeal was written almost as a conditional. It said that if she intends to file, it would be handled by other counsel. Counsel, who is not my brother counsel here, believed that it discharged its duties by filing this piece of paper. But the paper that it filed really is not a true notice of appeal. And so again, if the court wanted to dispose of this on that ground, I think it could do so. Second, let me just address something that my brother had referred to a number of times, and that is that father was found contemptuous of the judgment by not allowing visits. In fairness, Judge, this is a very complicated record, and so there was a lot of back and forth about complaints for contempt, but my understanding of the record is that father was not found in contempt of keeping the child from the mother. There was only, out of the whole battery of complaints of contempt that were filed, there was only one that father was found to be in contempt of, and that was relating to a check that I think he had already paid, or in any event, he cleared that contempt up by paying the check right away. But it certainly did not relate to father keeping child away from mother. It is unclear why mother didn't have the relationship with the child that she did. And so with that, the court is well aware, I think, of the standard, which is that the complaint for modification could be allowed only if the complainant shows a material and significant change, substantial change in the circumstances, and if a modification is in the child's best interest. And I think it's clear from the record that the mother did not satisfy either prong of that test. As to the material and substantial change, I understand my brother had made arguments about the contempt, and again, that father wasn't allowing visits. In the brief, he seems to focus on, or she seems to focus on, three arguments for a substantial change. One, that she got a new apartment. Two, that she got a daycare or childcare license. And three, that she's developed some sort of plan for the children. Your Honors, I'd submit that neither of these raised to the standard that would allow a modification. By raising the issue of the new apartment, I think mother, frankly, just misunderstands the nature of this case and really undercuts her argument.
But you filed a counterclaim, and you raised allegations, so is it your view that you met your burden to prove a substantial material change of circumstance to warrant a change to the parenting plan? So
the only modification that's under appeal, as I understand it, is mother's complaint for modification.
Correct.
Father is satisfied. He has sole legal and physical custody, and so he's not appealing anything.
You were looking for supervised parenting time. You wanted to move the parenting center closer to home and to make a change in the child support, right?
Judge, I represent father as an appellee.
Okay.
And so I don't believe we filed, I don't believe he ever filed any notice of appeal with respect to the
Right, then
judgment.
let me ask you a different question.
Yes.
So I was wrong about the name of the case. The case I was thinking about when I was talking with your opposing counsel is Schechter. And in Schechter, we upheld a decision of a trial court judge that suspended parenting time for 1 year. And that case had a significant amount of domestic violence and really focused on the best interest of the child. So here, Judge Cronin makes some findings about the child's preferences, which we know are not binding on us, but there's not really a fulsome discussion about best interest. It seems to focus on what mom did or didn't prove. If you assume, for the sake of my question, that it might be thin, but that mom did show a material and substantial change in circumstance, tell me why this judgment is appropriate.
Sure. Because it is not in the best interest. If your focus of the question is on the child's best interest, it's clear that a modification is not in the child's best interest. The GAL recommended that mom have no contact with the child, even on a supervised basis, until she engaged in reunification therapy. That I think is well grounded because she was considered to be a, quote, stranger to the child. And so it would just be very traumatizing. What little contact mother had with the child was I don't want to say inappropriate, I don't want to say it was traumatizing, but it certainly did not go well. And so the court was well within its right to adopt the GAO report that recommended reunification for any contact with the child, let alone the contact that mother asked by way of her modification. And so, Your Honor, Chief Justice had suggested, that the ball is in mother's court, and that's true. And I suggest to wind back the clock. a material and substantial change would have been if mother went to reunification, did the reunification, if it went well, if child was not considering mother a stranger, if child was showing some affection, which she was not doing in the supervised visits. If that had happened, mother could then very well have gone to the court and say, Judge, I have made the request, I followed the recommendations of the GAL, it's going swimmingly, and now I want additional time, or now I want legal custody. But she didn't do that. She skipped over that entirely, and I think that's the fundamental problem.
Can a judge still modify a judgment on a complaint for modification where he has found no substantial material change in circumstance?
I don't believe so, Judge. I think the standard is that in order to allow...
Well, but you have a modification here that I presume you like, which is no contact until she has reunification therapy.
Judge, again,
Go back to the last judgment?
Again, I represent father as an appellee. I don't believe he has not contested any issue with the judgment. My understanding of the judgment is that he has sole legal and physical custody, and there is no parenting time because mother hasn't done what the GAL recommended. The date of the judgment is July 5th, 2023. And so whatever that judgment is, that's what father is satisfied with. Mother is the one who's asking that be modified to get additional parent time, to get custody, to get, and again, she bears the burden, both on showing substantial change and that it's in the best interest, and she hadn't done that. Finally, Your Honor raised the issue of the GAL report. It is true, I have not read the GAL report myself because it was impounded and it was not included as part of the record appendix. But if anyone had any concerns about that, the parties could have called the GAL as witness. No one contested that any specific finding was wrong, or that mother doesn't raise that, hey, the judge misinterpreted what the GAL said. And so, we've all accepted the characterization of the GAL report by the judge as true and accurate. The judge credited the report, and I think, as Your Honor noted, the findings in that report are somewhat troubling. Again, mother may have had some mental health issues. That may be a problem with reunification if it goes forward. But suffice it to say, what little contact she had with child was troubling. And so based on that, it would clearly be in the best interests to not grant the modification. And in any event, mother had not made that initial showing that there had been a change in circumstances. And for that reason, I had asked you affirm the judgment of the lower court.
Let me just make sure there's no questions. Thank you very much. The case is under advisement. Counsel, these are always difficult cases. We thank you both for your advocacy.
Thank you.
Our next case is John Doe 523460 versus the Sex Offender Registry Board, docket number 24P357. Good morning, Attorney Rose. How are you? All right. When you're ready.
Great. Thank you. Good morning. May it please the court. My name is Rebecca Rose, and I represent the appellant, Mr. Doe. Your Honors, Mr. Doe's hearing was not fair because the hearing examiner denied the motion for funds and because she did not pay careful attention to the facts and the record in this case. I would like to start with the expert funds issue. To me, the issue here is fairness.
Was there an expert actually identified?
No, there was not. But I must say there are quite a number of sex offender experts in the field in Massachusetts. I don't think it's hard to find an actual expert.
Well, and the reason I ask, and I want to remind everyone, this case is impounded, and the facts in this case are particularly difficult and sensitive. So the reason I asked if there was someone identified is the argument that the board makes is connecting these issues with the offenses. So can you help me with that?
Yes. In fact, the SORB submitted evidence from the treatment center, and in that evidence, the treatment providers there actually did connect the BDSM with his offending behavior in numerous ways. In fact, and I do cite the I cited in my brief, but in the comprehensive report, especially the stable 2007 risk assessment, which the hearing examiner talked about quite a bit. She didn't rely on the conclusion, but she did consider it and talked about it. But in that, there are 15, he scored a 15, which is high risk or above average risk, but 7 of those, if you read the narrative behind it, and this is in the first volume, starting on page 179, if you read the narrative behind it, 7 of those 15 points relate directly to his BDSM behavior.
So that is the argument that if he had had funds, an expert may have been able to testify that the way he grew up and his childhood explains his sexual predilections, but then we have those being taken out on a minor, and that's where you lose me.
Your Honor, there's no doubt that this child could not consent, and that is not, I think that consent is not the issue here. The issue is deviance. The issue is risk and dangerousness. And the hearing, the treatment providers at the treatment center connected his risk and dangerousness to his BDSM. And what we
Yes, but doesn't it have to be something more than that? To get an expert, funds for an expert, don't you have to demonstrate that the expert opinion would be tied to one of the factors? And in fact, the SJC has indicated there are 3 of the factors in particular that seem to be factors that an expert might offer some helpful information on.
Well, Your Honor, my basic argument is one of fairness, because when he renewed his motion at the hearing, he said, specifically, counsel argued that there was this expert evidence that did link this behavior, this behavior that is not within the common knowledge, to his risk and dangerousness. And he wanted to be able to challenge that. And he does have a basic due process right to confront the evidence against him. So at that point, especially when the evidence came in from the treatment center and from the actual experts at the treatment center with opinions that linked his BDSM behavior with his risk and his dangerousness, that at that point, I believe it's a matter of fairness to be able to counter that evidence with his own expert.
The hearing, I guess the fundamental problem is that the hearing examiner didn't link the BDSM issue to a risk factor.
Well, Your Honor,
what is the prejudice?
Well, Your Honor, first of all, I actually think that the hearing examiner did. In fact, with 37, she does seem to link it. She talks about his long history of engaging in BDSM with his risk and dangerousness. And then later on, when she's discussing the 3 factors that need to be proved, she talks about the contract and the hair pulling. These are, in a consensual relationship, these are not problematic behaviors. So my argument is it was pervasive in the opinion. She didn't specifically link it to a factor, but she spent 2 pages talking about it, and she talked about it within the risk factors and within her final conclusion on the risk, the dangerousness, and the internet. She actually talked about the BDSM practice. So my argument is that it simply wasn't fair for him not to be able to counter this evidence because she did rely on it. And she did, and so she doesn't say specifically, I think this makes him a high risk based on this factor, but she talked about it throughout the opinion, and it literally does come up in factor 37. And for that reason, Mr. Doe, especially after the hearing, after all that evidence came in, and she still didn't allow it, and yet was allowed to consider the expert evidence that the SORB submitted. And I submit that was unfair, and it made the hearing unfair.
All right, so assuming that a mere reference to BDSM or multiple references to it by the examiner is enough to justify funds for an expert, what would the expert have offered that would have been helpful to the plaintiff.
Well, deviance is a term of art in sex offender therapy, and the treatment center talked about deviance. He got points on his high risk for deviance specifically related to BDSM. And I think the issue here, again, the issue is not about offending against minors. There's no issue about consent there. But the issue is that the BDSM doesn't make him more dangerous or more high risk. And that's what, in fact, the hearing examiner seemed to conclude, especially in Factor 37, the other things that the hearing examiner is allowed to consider. And so that's, to me, the real issue, and that's what counsel argued at the hearing, that to be able to counter that expert evidence that specifically talked about the deviance and the high risk that the treatment center connected to his BDSM. So that, and she did mention that at the hearing. And that is my argument, and that is exactly what sex offender therapists and sex offender researchers do talk about, especially risk and deviance. I mean, I do want to remind the court that even though there's a lot of talk about past behavior, this is really about, SORB hearings are about predicting future behavior based on empirically validated risk factors. And so no matter how bad the facts sound, there is room for experts, there is room for scientific opinion, and these risk factors, some of them are not clear on issues like this. I mean, there's no case law. I didn't find any case law on this issue. So, I mean, this is a pretty specific issue that it hasn't. I've been doing this work for decades, and it hasn't come up in my practice. So, again, it kind of cries out for an expert especially to counter once the experts on the other side said it connected to his risk and his deviance.
Just to be clear, are you arguing that the hearing examiner considered this issue divorced from the context of your client's offending behavior?
No, I think she connected it.
Connected it,
yes.
Right. But then you say you needed an expert to address the issue outside of the context of the clearly non-consensual.
No, the way she did connect it, that when she did consider that his long history of engaging in BDSM, when she did connect it to his risk and dangerousness, and then later on when the contract and the hair pulling and the behaviors, I mean, she kept saying
that's all offender conduct, right? So you seem, I just don't understand. You saying you needed an expert to assist on this issue as a general matter outside the context of offending behavior, but it doesn't seem like the hearing examiner
I think both.
Relied on that consideration outside of offending behavior.
Well, respectfully, Your Honor, I actually disagree. I do think
I'm just trying to understand your position.
Yeah, I do. I mean, when she spent 2 pages talking about it, and so it was clearly pervasive in that opinion, and it was pervasive in the records from the treatment center as well. Like, this is an issue that they said the words, like, I don't think that the evidence of his BDSM, there's not enough to say he's deviant, but then they gave him points for deviancy because of it. So I think that, again, it was, he wasn't allowed to counter any of that evidence or the evidence, the pages in the hearing that the hearing examiner decided on. And I think, using it under Factor 37 instead of Factor 1 because, that it's not enough to avoid the issue. If she really thought he was deviant, it would have been addressed under Factor 1, but instead she puts it in Factor 37. And I think that's a little disingenuous to say she didn't connect his actual BDSM beliefs with his risk and dangerousness. So I would like to spend the rest of my time talking just briefly about the arbitrary and capricious application of the other factors, particularly Factor 13 and Factor 28. Factor 13 is about noncompliance with community supervision. Now, there seems to be a disagreement in the record. The hearing examiner says that there were 7 probation violations. The treatment records say there are 7, but they list only 4. My brother lists 4. I found 3, but honestly, when I was doing my review for this argument, I did miss one of the 2011. So that was my mistake there. So we have 4, but the confusion actually, I think, addresses my point that the hearing examiner didn't carefully consider this record when she considered and weighed the noncompliance with community supervision. And in fact, she's required to consider the number and the seriousness of the violations. 2 of them resulted, the cases were dismissed. One happened when he was 14 years old. The other one, he failed to pay restitution. And again, you can violate parole for a gajillion reasons. You can be late to court, you can be late paying a fine, and the due process requires a careful consideration. This is not accounting. This is not about counting the numbers. This is about considering what's actually on the paper. And then, as it relates to factor 28, supervision is a protective factor, and he's on probation for 10 years with a life sentence hanging over his head. And again, there's like a qualitative difference between, failing to pay a fine and you've got a year of county time over your head when you're young in your 20s with when you're in your 40s and you've got 10 years of probation with a life sentence hanging over your head.
What do you say to Mr. Shania response to that, which is that even if there was error in the application of some or all of these 4 factors that you've identified, the error was harmless because of the totality of the circumstances in the case?
Well, I believe this court has said many times that this court can't weigh the factors. Only the SORB hearing examiner can weigh the factors. And if so many of them are misapplied, again, this is not about past behavior. This is about predicting future behavior based on these factors. Even if some of these factors were misapplied, I still believe this court needs to send it back to the hearing examiner to actually weigh them.
If we said the 4 factors were misapplied, is that why you say he's a level 2, not a level 3?
That's what was argued below. That was what was argued below. That, I don't think that's my job I can't weigh the factors, but I do believe that.
So you think he gets a do-over?
I do. In fact, that is my argument, but particularly for the expert funds issue, particularly because of the unfairness and not being able to challenge the expert evidence that did link his behavior, his BDSM behavior, with his deviance and with risk and dangerousness. I will be happy to rely on my brief for factor 9 and factor 10, but I would like to remind the court that, again, under factor 10, it is not a counting exercise. And again, she listed all of the offenses that are on his Board of Probation record without, he had 8, notwithstanding the charges that were dismissed for indictment, there were 8 dismissed charges on his adult record, there were 11 filed or no proster dismissed charges on his juvenile record, and she didn't consider them. She simply counted them. And again, due process requires a more careful consideration. Indeed, I think that the hearing examiner wrote a lot of words, but I don't think that they made a meaningful and considered analysis of the actual facts. And for that reason, we asked for a remand for a new hearing. Thank you.
Thank you. Attorney Shania.
If it pleases the court, Chief Justice Blake, David Shania for the board. It's a pleasure to be here on this rainy Wednesday morning. The board's position is that there was really no basis to issue expert funds in this case, obviously. I think I've covered that overall pretty well.
It's an interesting question because without looking at your papers, right, you sort of suggest the hearing examiner didn't rely on the BDSM per se, but she certainly relied on the facts of what this offender did to these victims. Isn't that the same thing?
No, it's under DOE 496501, as we know, the hearing examiner has to determine the possible danger someone poses if they reoffend. And it also says you look to his past sex offending behavior. What the hearing examiner is basically saying, look, this individual, in the records show that enjoys the BDSM lifestyle, if he decides to reoffend against another underaged child, he's most likely going to do those type of acts with that child, which increases the danger he poses. Now, getting back to factor 37, she never says, the hearing examiner never says, because he suffers from BDSM, he poses a higher danger. Again, it's focused on the danger he poses to a future victim, i.e. someone under the age of consent, because in this case, the hearing examiner acknowledges that consenting adults who would participate in this behavior or this type of sexual behavior, it's perfectly legal. So I think that's where the focus is. Now, interestingly, at Factor 37, using the dangerousness equation, I've just gotten notice that the SJC is going to take that case up. And I will be on some future cases that are pending for next month, filing a motion to stay those based on that. But part of my argument in this case is
That's very interesting to me. Which factors specifically are they looking
what
at?
they're looking at is, can you say Factor 37?
Basically, the argument being 2 has become 37.
No, actually, not 2. If someone engages in repetitive sexual behavior, and can the hearing examiner now say that under Factor 37, repetitive sexual behavior indicates increased danger because of the increased risk it gives to the future victim, theoretically.
Could you let my clerk of court know that motion for stay is coming?
Yes, I'll let the court.
We've been looking at those factors.
Right, well, that's interesting. I've been saying for a couple of months now, I think it was a panel with Judge Blake, in fact, I said, this is a case that you really should write a published decision on, because these issues are coming up, and I think I've written 6 briefs on it in the last month and a half. So it is an issue. I think the SJC is going to resolve that issue. But in this case, even if the SJC ruled against the board in this, it still goes back to the harmless error in the sense that the hearing examiner looked at that to say, okay, his risk of danger is higher if he reoffends, but that doesn't change the overall analysis that this individual is at a high risk and a high danger because of his prior sex offending behavior, because of his inability to follow the law. He's always not only committed crimes, but while on probation, he commits crimes. There's no indication that there's anything that constrains him, and there's no indication that he would be constrained in future sex offending behavior against juveniles.
Are you aware, you've been with the board for a few years now, are you aware of any other cases where expert funds have been allowed for somebody claiming BDSM as a defense to the registration number?
Interestingly, I kept thinking about this last night, and I figured out since 2005, I estimate I've done between 6,000 and 10,000 of these cases. This is the first time I've even seen this issue. In fact, I had to look up online what BDSM was and realize that it's, and again, you can liken it to a situation where if these are consenting adults, they have the right to engage in this behavior. There's nothing wrong with that. And you look at it, say, if you're a heterosexual, if your preference is heterosexual sex, there's no crime engaging in adults consenting to that type of sexual behavior. It's when you start going towards juvenile individuals, people underage, and commit that offense, whether it's heterosexual, whether it's BMSD, whether it's any type of sexual behavior that's not legal for adults, but you put that on a child, now you're a sex offender. And that's what this case is.
I guess that's the question, really, right? Is there some expert out there? I mean, they're not going to be able to say that this behavior explains offending against a juvenile because a juvenile can't consent, but is there the potential that an expert could explain the risk of future harm from somebody who has this proclivity? And you're saying to me no, because it's a juvenile.
Because it's a juvenile. I think that you have to look at it in the lens that this individual didn't engage in consensual adult BMSD. He actually perpetrated it on a child and also had sexual relations with a second child, or attempted sexual relations with a second child. So I think that looking at these cases as a whole, this individual is outside the bounds of what the BDSM lifestyle encourages or is about. And I don't think you're going to find an expert that says because he suffers from BSMD, he now has some kind of lowered risk when it comes to his interactions with future juveniles. I just don't see that happening.
But okay, so the MTC expert seemed to link BDSM in more general terms with deviancy. Would you agree with that?
Yes.
And so if the hearing examiner had kind of relied on that rationale, then there might well have been a problem with not allowing Doe to have an expert to kind of rebut that. Wouldn't you agree?
I would agree.
Okay. So when the hearing examiner made this decision on the expert funds, she kind of tied her hands at that point to not go down that road. Would you agree with that? To sort of go down and to sort of cabin her analysis to...
I kind of lost you there.
Okay, well, sort of, I mean, because she denied expert funds to sort of allow this issue, it wouldn't have been fair to sort of then make a risk determination that kind of examines BDSM generally, not in the context of what behavior actually occurred here. Would you
Right.
agree? Yes.
The case law is very clear that if you deny expert funds, but then accept the opinion of an expert on that issue, then you should have given the funds. That's not what happened in this case. The only thing the hearing examiner looked at that evaluation to say is that static 99 and the 2007 stable 2007, he was above average risk. Never really talked about it much more than that, and did not say that there's a connection between the findings in the 2007, stable 2007, relate to some type of sexual deviancy because of his BSM. She didn't do that. The hearing
My only
examiner-
point is that this issue of fairness, which I think you're right to acknowledge, kind of gets away from whether or not Doe made a sufficient showing
Correct.
in his motion for expert funds about the relevance. It really was sort of, I'm not going to be considering this analysis going forward, so
Right.
therefore it's not an issue. That's more really what happened here.
Right.
Okay.
Right. And like I said, I think I've covered these issues very well in my brief. Unless there's other specific questions, I'd be more than happy to rest on my brief.
I don't see any other questions, so we will take them on your brief. Thank you, counsel, both.
Thank you.
Very interesting argument. And again, let Clerk Tuttle know about the stays that are going to be coming our way.
I'll call Mr. Tuttle on my way home.
Please do. Safe travels to both of you.
Thank you.
Our next case is Dorothy Luck versus Michael Luck, docket number 24P438. This case is partially impounded, I believe, based on the financial statement, so just a reminder to counsel. Good morning.
Good morning. Morning, Justices. May it please the Court, my name is Linda Ouellette, and I'm representing Dory Luck, who was formerly known as Dorothy Luck. This case presents an appeal. It's a consolidated appeal of an amended judgment from the Norfolk Probate and Family Court and two contempt judgments that were entered by that court, both of those in November of 2023. I'd like to focus first on the divorce judgment. And the issue on appeal is whether or not the lower court erred by eliminating a provision in the original judgment of divorce regarding alimony. In the original judgment of divorce, the court established an alimony award based on a percentage of the difference in the party's gross income, the husband's salary from his medical practice, and attributed income to the wife. And the court then required that there be annual adjustments of the alimony in order to afford the parties an alimony award that had that same percentage of the difference in the gross incomes. And that amount was 32.5 taxable to the wife and deductible by the husband, which may be irrelevant to anyone who practices in the probate and family court. Importantly, when the court amended its judgment to eliminate those annual adjustments, the court gave no rationale why it made that amendment. It did not amend its original findings, it did not delete or add to any of the findings of fact, and it did not amend its rationale. And while the appellee is correct that the appeal is from the amended judgment, I think in evaluating the court's discretion, one has to look at the original judgment and, more importantly, the findings and the rationale that gave rise to that original judgment, which is an alimony award that had those annual adjustments to allow the wife to maintain the station of life during the marriage to the extent that that was possible.
So I agree that it's concerning that there was an explanation for the change in course here. We can read into that the judge was responding to husband's motion to alter, which said, this offends Young v. Young, right? So
Correct.
Let's get right to it. Why did the original judgment not offend Young v. Young?
Well, Judge Young was an appeal from a divorce judgment in which the lower court had ordered a percentage-based alimony from day one. The very first moment the parties were divorced, the wife was entitled to share in a certain percentage of the husband's income, adjusted annually year to year. Unlike the present case, the lower court order in Young would have allowed the wife to expand her lifestyle beyond the marital lifestyle. And in fact, when you read Young, the lower court judge specifically envisioned that when she entered the alimony award. Certainly in Young, had the lower court, or had that order been allowed to stand, it would have flown in the face of longstanding precedent of this court and the Supreme Judicial Court that alimony is intended to maintain the lifestyle to which the parties became accustomed during the marriage. It is not a lifestyle which the recipient would have enjoyed had the marriage remained intact, and that was the issue in Young. It would have expanded the lifestyle of the recipient. But conversely, in this case, it is not the lifestyle that the parties should have, in hindsight, lived if they wanted to live within their means and make different decisions about how they would give their life. It is the lifestyle that they actually chose to live, which was towards the end of the case. It evolved during the marriage, but at the end of the case, it was an upper middle class lifestyle that everybody agreed was beyond the means of the parties. And that's reflected in the fact that they had almost no assets at the time of the divorce. They did have retirement assets. Their total assets were about $700,000. About $500,000 of that was in retirement assets. They didn't own any real estate. They were both heavily in debt at the time of the divorce. But that is the decision that these people made. They made the decision, and this is right in the...
But when you were reading that language, what struck me is I was thinking to myself that that sounds exactly like this case. Because, I mean, what if the husband's income, if it doubled in 2 or 3 years because he moves up the partnership ladder? Does that seem fair that that should be adjusted?
If his income rises to a level, again, the parties lived in reliance on that income in how they chose to live their life. But if his income expands to such a level where it is clearly excessive in light of the marital station of life, then he would have the right to come in on a modification of the judgment to say that the changes in circumstances were that his income was now so much higher than it was at the time of the divorce, that it is now excessive in light of the marital lifestyle and what the wife would need to be able to maintain that lifestyle.
It seems to me like debt is the key to your argument here, right? The existence of the debt that's tying down both husband and wife, and that they're not able to kind of even maintain the status quo without the additional income that they anticipated that would help them to sort of get out of the hole they had placed themselves in. I mean, is that really the critical factor that distinguishes this case from Young, in your view?
I would say it is debt. It is also the fact that they were not accumulating any assets. In fact, they were, towards the end of the marriage, they were living off assets. They sold the house. They started to use some of the proceeds to be able to pay their expenses, and their expenses included debt service. The husband had to liquidate some of his retirement account to raise money to be able to pay the debt. So it is not simply the debt. It is also how they lived their life, foregoing asset accumulation incurring huge amounts of debt. The debt that these parties had accumulated as of the time of the divorce was over $1.1 million combined, which included a lot of things. Yes, it included family loans, although the court found that those were, in fact, loans and not gifts. But it also included credit cards. It included student loans. So it included real debts that were not going to be overlooked or forgiven simply because the parties had gotten themselves over their head in how they chose to finance their lifestyle.
Let me ask you a question that is going to give me a minute to ask it, because it has a couple of parts to it that I want you to think about.
And I read them down because I'll...
You might need to.
Okay.
The Alimony Reform Act did more than just change our alimony structure, right? It amended 20834 to include, as a consideration of asset and debt division, the amount, duration, and nature of alimony. And here we have an upside-down marital estate where, and I know that you and Mr. Kane quibble about the numbers, but just give me the rough math. I think roughly the wife got 60-40 on the asset division, and the husband was allocated roughly 80-20 on the debt division.
I don't agree with that, Judge, because there's some double counting.
Again, for the purpose of my question, how does the structure of the asset division and the debt allocation, even if we were to use your numbers, and consideration of the nature and amount of alimony as it's now a factor under 20834, change your argument, if at all? And Mr. Kane, I'm going to ask you the same question.
If there was a huge amount, if the 60-40 division had given the wife a significantly greater amount, or if the amount of debt that he was absorbing had a meaningful impact on the amount of the debt that the wife would have to maintain on a taxable alimony award, okay? If the actual numbers, not just the percentages, had a meaningful impact, I would agree that that would be a factor. But when you look at this case, you say, all right, she got 60% of the assets, 60%, an extra 10% of $700,000, she got an extra $70,000. Yes, he took on more of the debt, but he also took on more of the debt with that upward earning potential that was not, it might happen. It was something that they knew about. It was something that they anticipated. And most importantly, it was something that they relied upon. If this was a case where the parties had lived within their means, all right, they did not overextend themselves. They didn't take 2 vacations or a vacation to Switzerland and they took 1 vacation, or they looked at the finances and said, we have 3 children. We have to educate them. Maybe we can't send all of them to private school. Had they done all of that, but that is not what they did. They ended up so largely in debt, and you look at that and you say, well, why would somebody have done this? This was a doctor and a smart woman. Why would they have done that? Well, they made the decision. We're going to bet on the amount of increased income which this doctor is going to get as he climbs the track. And it's not something that they just speculated, including in the record appendix and an exhibited trial, was a partnership track, or is a written track where anybody could look and say in year 1, in year 2, in year 3, by the time Dr. Luck reached full partner, which he did in the middle of the divorce trial, he was now getting not only a full partner salary, but he was participating in 100% of the profits of that practice. They knew that was coming.
So if they had been divorced before that happened, she would have had the right to come in on a mod, and maybe she would have been successful, maybe she wouldn't have been, right? But essentially what the judge did here and then undid is built in what we said, I believe in Hassey, that we shouldn't do, which is a self-executing modification.
But it was not. It was not, because in Hassey the difference was that there was a percentage, but there was no finding that the wife would need that additional amount. The findings did not support. It was just, well, she should get an extra percentage without any finding that that extra percentage was necessary for her to maintain the marital lifestyle. An automatic adjustment, an automatic amount of money saying, well, she gets a percentage. Had they lived within their means, and to your point, if it had happened and they lived within their means and they knew at some point in the future, the husband was going to reach full partner status, that would have been a very different case, because they would in that fact pattern, they would not have lived their life in reliance on that future income. And that is what distinguishes this case from Young. It is the reliance on that income, and it is the decision to live a lifestyle that anticipated that. It's a very different case to say, well, maybe he'll make more money in the future. And I agree with that. Maybe that would give grounds for a modification, but maybe not, because at that point, they were living a marital lifestyle consistent with their means.
Do you agree with the husband's brief at page 27 where he says you did not, or the wife did not raise the issue of savings below, so it's not preserved?
I don't think I think I argued that as an example. Okay, yes, there was no finding that the party saved. To the contrary, there was a finding that they had not saved, and that was evident in the financial statements that were submitted at the time of trial. I do want to, if I might, address an argument, and that is, you know, normally we don't get the opportunity in these cases to sort of do a test run and see whether or not the result of the judgment, in fact, is unfair. Well, we have that in this case because this is a consolidated appeal, and there was a contempt action that was heard by the court about 8 months after the original judgment was issued. And if anything shows the inequity of the court's amended judgment, which would have limited, which did, in fact, limit the wife to that fixed amount of alimony, which, again, was on the base salary, Judge. It did not even include these large bonuses that the husband had received. But that base amount was the amount that the wife was receiving at the time of the contempt hearing. And if you compare her financial with the husband's financial, and I don't want to get too granular in it, legal fees from the divorce of $78,000, which she could not pay. Look at the husband's. Zero debt, multiple credit cards, all legal fees paid, no credit card debt. She, on the other hand, had huge credit card debt. And my brother likes to point out that I'm not the first lawyer in the case, and I'm not. I don't think I'm 7. I think I counted. I think I'm 6. But if you look at the legal fees that she owed to law firms, it's hardly a surprise that she would have difficulty maintaining an attorney that would stay in her case. She had enormous debt. Her debt had hardly budged. She had huge carrying costs. And the husband, on the other hand, his income had increased to about $320,000 more than he was making at the time of the divorce. He got a $446,000 bonus, which he calls a bonus. We think it's something different, and that's being litigated in the lower court. She shared in none of that. And he was now in that position to do what the parties both anticipated they would do, which is they would share that.
Your time is starting to expire, and I know Justice Toone has another question.
I just want to ask about footnote 9 in Young, and
may I grab my?
Sure, I can just give you a quick. This is the exception where the SJC contemplates that there could be an annual adjustment in the event of the quite different circumstances where one spouse was on the cusp of being able to afford a more expansive lifestyle after separating from the spouse who had financially supported him or her while he or she completed medical or business school.
Right.
And so there is the idea of some kind of compensatory or reimbursement alimony to make up for that loss. But even there, the SJC, if that were allowed, they said it would only be for a limited period of time. And of course, here the original judgment wasn't limited in any time. So one, do you think your situation is analogous to that kind of scenario? And two, would you agree that if so, there should be some kind of time limit on any annual adjustment that's opposed to allow wife to get out of this hole of debt that she's in now?
There could be a time limit, and that might be something that the lower court should have done if it was going to enter an amended judgment, to go back and look at those findings, and most important, look at the rationale and see if the alimony award could be adjusted to address that particular issue. But what I'll point out, both with regard to the case cited in footnote 9, which I think may have been Zaleski, and also the other cases, is there's not going to be necessarily analogous facts. Young is very clear that these types of awards that are not a base amount where they are self-adjusting or they have annual adjustments or they're percentage-based, whatever you want to call it, these are very fact-specific cases. They are the exception to the rule, and we do not contend that we are not standing here seeking an exception to the rule. But in whether it was Wooters or whether it was Zaleski or whether it was Stanton Abbott, in all of those cases, a percentage-based award was issued because the standard alimony, the usual way we did it, would not have accomplished justice. That was the case in the case cited in footnote 9. That was the case in Wooters. All those cases, and they are the minority of cases. But in those cases where there is something specific about the facts of that case, in that case, I think Young is saying that percentage basis award, even though they are the exception, may be appropriate. And I submit in a case like this, where you have these people who clearly,
I have to ask you to wrap it up.
who clearly lived beyond their means. I just want to briefly state on the contempts, I'm going to rest on...
I'm sorry, you're going to have to rest on your briefs on that.
I
Thank
will
you,
rest
Attorney
on my
Willett.
brief. Thank you, Your Honor.
Attorney Kane.
May it please the Court. Good morning, Your Honors. Chief Justice Blake, Justice Hodgens, and Justice Toone. My name is Martin Kane from McGrath and Kane, and with me is Joanna Gibson, and we have the privilege of representing Dr. Luck today. I will demonstrate to this panel that the lower court acted well within its discretion to determine an appropriate alimony award.
So I have to just jump right in because that's how I am. I am very troubled by the fact that we have an amended judgment that makes a wholesale change to an alimony award with no explanation whatsoever. No changes to the findings, no changes to the rationale. I've read your motion several times. I understand the basis for your motion, but why, at a minimum, doesn't this go back to ask her to explain why she did what she did?
When you say my motion, Chief, I think you're referring to the motion alter and
Motion to
amend?
alter and amend.
Right.
Yeah.
And so the motion...
Cite Young, I get that.
Right. Well, I think that if there were to be, as my sister wants, the concept of a 32.5% that just goes on forever, then there would have had to have been findings by the trial court that are similar to Wooters, Stanton Abbott, and Drapik in the cases that Justice Toone was talking about with my sister. Those didn't exist because they weren't, this wasn't part of the court's analysis. When the court looked at Young, I presume, and read specifically footnotes 8 and 9, the court realized that the language in Young is clear, that there is no statute or case law that suggests the recipient spouse be entitled to a lifestyle beyond what was experienced during the marriage.
But how do we know that that's what the judge thought? She doesn't tell us that.
Well, because she read the motion to alter and amend in paragraph 4, I believe it was, where we cite Young and provided the case to the court. My presumption is that the court read it and then adjusted on November 3rd when she amended the final judgment.
What if she read paragraph 5 and said, that's interesting, but I've decided I'm going to amend it because of this, this, and the other thing? We are a court of error correction. We're not making findings of fact. I have no idea why this judge did what she did. I have assumptions, but that's all they are.
Right. When you look at it globally, though, Chief, the court, this court in the SJC, has afforded the trial court, especially the probate and family court justices, wide latitude and wide discretion. Mm-hmm. The case law is abundant with dicta that says that the discretion is afforded to the trial courts in fashioning alimony. So when you look at this globally, you say, did the lower court analyze everything? Not just 4953, but 34 as well. When you look at what this court did in its ultimate judgment, it gave 80%, 78 point something percent of the debt to the husband, 20% to the wife, 60% of the assets to the wife, 40% of the assets to the husband. And in addition to that, the husband was required to pay the remainder of the youngest child's tuition at Tufts. There was a 76-24 division of the debt, which is included when you read our brief, of his total 80% of the debt. On the children's student loans that were then outstanding. When the court demonstrates in its 37 pages of 281 findings that she analyzed all of the factors in this case, this specific case, this case where these people decided to live way over their skis, everybody agrees to that, that the analysis was proper and done, and the discretion that this court and the SJC affords to the trial court should not be disturbed. There is nothing clearly erroneous in the findings that support the annual award of $267,000.
When she amended the judgment, the trial judge made not one change to her findings or rationale?
Are you asking me if I agree to that?
Yes.
I do, yeah, I do. But I would point this out to the court. When you look at the year that the wife filed her complaint for divorce, which was 2018, so we know, if we look at it at that time, what was the marital lifestyle at that time? His total income for the year 2018 was $597,000. That is, the award of $276,000 is 49%, almost 50% of his gross income in the year that the wife elected to file for divorce. And so when you look at Young and you look at the cases that surround Young, that talk about there shouldn't be an extension going forward, that's because we look at contribution. Contribution is one of the factors under 208-34, and where is the post-divorce contribution? This judge put the wife at 50% of his gross income in the year that they elected to get, or she elected, excuse me, to file the divorce. I don't think that this court can find that that is some sort of abuse of discretion or is clearly erroneous. I recognize that the findings didn't change, but to suggest that this court didn't put a full effort into 37 pages and almost 300 findings with her rationale that supported why she came to this conclusion due to the nature of the debt that these people lived, I can't see that this court on review can suggest that she abused her discretion.
Well, let's go back to the, clearly, I think Young played a role in the decision. We can infer that from, that's the only thing in the record that indicates why the change in decision was made. So let's get to the heart of the issue.
Yes, sir.
The wife's position is that in a situation like this where the parties accumulate a tremendous amount of debt in anticipation of a larger salary down the road, and that's a factor that can be taken into consideration, particularly when the husband's salary is going on this upward trajectory. And that sort of provides for an equitable distinction from the general rule established in Young. So can you address that? Do you agree with that? Is that possible where there's accumulated debt that's kind of bearing down on both parties, and that needs to be taken into consideration in determining what levels of alimony should be paid going forward, at least for a certain period of time?
Yes, Your Honor. I can answer it like this. The trial judge analyzed both financial statements of both clients, not just with regards to debt, but with regards to income, expenses, et cetera. And in her analysis, the court found that the wife's need, the wife's expenses, were overinflated, as we quite often see in the probate and family court, both sides. I don't want to just say wives, but both parties do it, right? And so in her analysis and her review, this court determined that the appropriate amount of need for the wife was $216,000. And she ordered an amount greater than the need, I would suggest, realizing that there was debt, albeit only 20% of the marital debt, was afforded to the wife. And so that $60,000 difference between the 216 and the 276 allowed the judge to provide for the wife to have an ability to pay down marital debt. Only 20% of that marital debt. Now, when my sister suggests to you in November, after the amended judgment came out on November 3rd, that there was a hearing before the court and she had, the wife had the significant debt. $84,000 of that was attributable, to the wife's decision not to pay her taxes on her alimony. That wasn't marital debt. That was debt incurred after receipt of support.
I'm not sure that getting into all the details of all the different factors that were at issue below gets to the, I really want you to address the question generally. Is this kind of situation something that a court, even after Young, can take in consideration, the party's accumulation of debt as a factor in considering whether annual adjustments can be made going forward? Can you address that level, that question at that level of generality?
The court, I just want to make sure I understand it, Judge, and I apologize. The court, you're asking me, can the court consider this debt and rationalize it by saying that she should, the wife, the recipient, should receive an extended amount of alimony or an
annual
increase?
adjustment, at least for a certain period of time. Is that allowable? Is that something that is consistent with the SJC's decision in Young, in your view?
Well, yes, I think it's allowable, but I think it's the minority, as Young says, right? It's the rare exception, as Young says, right? And I don't think that that exception exists. If you're asking me, is the 20% of the marital debt consistent with a rare exception that was carved out for Wooters or carved out for Drapick or carved out for Stanton Barton? No. I would say absolutely not. I don't think it rises to that level. It's only 20% of the marital debt, and there was a $60,000 annual cushion based on the trial court's findings.
So go to the question that I asked Attorney Ouellette, which is that now that we know that Section 34 includes an analysis of the amount and duration of alimony, the judge did not do that here, but thinking through that concept and what was the division of the assets and the assignment of liability, does that help or hurt your position?
I think by the court giving the majority of the liability to my client, the income earner, absolutely justifies the annual award. I think the court giving the recipient the majority of the albeit small amount of assets, but all, as my sister said, and I agree, the majority of it was retirement, 60% of that versus 40 to my guy. I think that all folds into the court's overall thinking that those two, the plus of the extra to the wife, the minus of the liabilities to the husband, and the $60,000 cushion would allow her to, the recipient spouse, the wife, to move forward and be able to dig herself out, as somebody said earlier. I think what's important to understand, the net effect is that my client was at, and it's cited in the brief, was at a negative 220 when this divorce was over, 220,000.
Can I ask you about footnote 9 in Young, because there's been some discussion about Zaleski. I happen to have been the trial judge in Zaleski.
I'm familiar, Your Honor.
This case, though, Zaleski was a rehabilitative alimony case.
Right.
This is a general term alimony case.
Right.
So when we're looking at what the wife might be able to do in digging herself out, I don't see this comparable to Zaleski in that sense. Zaleski was about, in 5 years, she'll be able to be self-supporting and will no longer have a need for alimony, whereas I understand the argument here, this is more about she's been saddled with a portion of this debt that she can't meet unless she gets this upward annual adjustment. Do you agree that this is a different analysis than Zaleski?
I think so. I mean, I think that both Zaleski and clearly from the reading of the findings and the ultimate decision of the amended judgment, both contemplated that they would have to, the recipients would have an opportunity to receive reduce, and move on, as the court said. I think that this was more than fair to the recipient spouse in this case, as it was in Zielinski. And they were, right, two different general term versus rehabilitative.
Why are you entitled to fees?
Well, Judge, I think I'm entitled to fees because I don't think that there's, when this court looks at from a 10,000-foot view, is there anything where there was clearly erroneous by the lower court? No. Did the lower court violate or abuse its discretion, given the plethora of case law out there? No.
Do you think this appeal is frivolous then?
And on the contempt, my last one on the contempt, to get to your answer, on the contempt, the wife stood in front of the trial court and testified under oath with regards to the contempt. I didn't know where to send the money to the schools. I didn't know who to address it to. I didn't know any account numbers. And
What about the contempt with respect to the wife failing to pay her parents' debt? Was
well-
there a clear and unequivocal command in the original judgment that she needed to pay that in full?
I think there is. I just want to finish the Chief's answer, if I may.
Okay.
The trial exhibits from June of 2018, 24 through 47, listed all the addresses where she could have sent the payment. My proposed judgment in March of 23 listed them, where she could have sent the addresses and the account numbers rightfully. And when she stood in front of the judge and said, I didn't know, the judge found her not to be credible. And so that's another reason why I think we should be entitled to fees, because I think that's absolutely frivolous. Justice Toone, to get to your
Was there a clear and
question.
unequivocal demand for the payments to her parents that had to be made where there was no specific timelines or end dates?
Yes, I think there was a clear and unequivocal command and a clear and unequivocal disobedience. In Ray Burchell lays it out for us. I would suggest to the court, when you read the transcript, which is incorporated in there, there's a back and forth, an exchange between the wife and the court. And I think the court was very offended when, upon learning that the wife had changed, had served him with the execution on Prince Street in front of Monica's Trattoria on the night of the boys' graduation. I think she was offended that she took the life insurance policies and surreptitiously put them in her parents' names. And I think the judge...
Maybe so, but she was found in contempt for not making a full payment to the
That's
parents,
correct.
right?
Well, she
And so-
sidestepped it. What she tried to do, of course, was take the order of the probate and family court, run to the Superior Court in collusion with her parents, and then get an order, a summary judgment out of the Superior Court, and run back to the husband who was not ordered to make that payment, she was, and have an execution. I think that was offensive to the court, that she absolutely colluded. That's a clear and unequivocal disobedience.
We will have to leave it there. Counsel, thank you. Excellent arguments. The case is under advisement. We are going to take a 10 to 15-minute brief morning recess. When we return, we will hear the Adams case.
Thank you very much.
All rise, please. Court is now in session. Please be seated.
Good morning again. Our next case is John F. Adams versus the Colonel Christopher Mason, docket 24P236. Attorney Krumholtz, good morning.
Good morning, Your Honors, and may it please the Court. Assistant Attorney General Rebecca Krumholtz, on behalf of the appellants, the Superintendent of the State Police and Executive Office of Public Safety, which I'll refer to together just as the State Police. I'm here today to ask that you correct the clear legal error committed by the Superior Court by vacating the decision below and entering judgment in favor of the State Police. Trooper Adams brought this action under Chapter 22C, Section 43, for judicial review of the Colonel's final order sustaining a decision by the Duty Status Board to suspend him without pay, pending the outcome of an internal affairs investigation into allegations of overtime fraud. In that final order, the Colonel concluded, based on a review of the full and fair post-deprivation administrative hearing record, that the evidence sufficiently supported the allegations of overtime fraud relied on by the Duty Status Board, and that therefore the suspension without pay was appropriate. The Superior Court, having erroneously confined its review to the duty status hearing record, reversed that decision on grounds that Adams was not afforded due process before the Duty Status Board. But the Superior Court acted in clear contravention of statutory and constitutional law, and its decision should be vacated for at least 3 reasons, each independently sufficient and together an overwhelming basis for such action. First, the Superior Court lacked jurisdiction under Section 43 to directly review the Duty Status Board's decision, where it was neither the subject of the appeal nor the department's final decision. It is the Colonel's decision to sustain the suspension without pay following the Section 43 hearing that Adams appealed to the Superior Court and that the court had authority to review. A decision that even the Superior Court seemed to concede found adequate support in the Section 43 hearing record, adequate evidentiary support for the suspension. Second, and in any event, Adams was afforded the minimal process he was due at the preliminary duty status hearing. And third, even if the preliminary duty status hearing were procedurally deficient, any error would be harmless, where the evidence presented at the subsequent full and fair Section 43 hearing was clearly sufficient to support the allegations made at the duty status hearing and to sustain the suspension without pay.
Ms. Krumholtz, what remedy, in your view, is available to someone who's been treated unfairly by the Duty Status Board?
An officer who's treated unfairly by the Duty Status Board has the right to appeal that decision to the Colonel and is entitled to a full and fair Section 43 hearing before the Colonel or the Colonel designate. At that hearing, the officer or trooper is entitled to call witnesses, enter evidence, and rebut any allegations or contest what occurred below. The purpose of the Section 43 hearing is to create an expanded record to effectively rehear the issue that was before the Duty Status Board.
So what happens, just as a hypothetical, say there is a duty status hearing and the trooper is suspended without pay, and it goes to the Colonel and the Section 43 hearing, and the Colonel says, oh, that was a mistake, they shouldn't have happened, reinstates the trooper, but does not provide for pay for the period of time that the trooper wasn't paid. And what happens then? Can the trooper then go to Superior Court and say that the Colonel did not adequately remedy the deprivation that occurred at the duty status hearing?
I believe that under Section 43, the trooper could then appeal that and say that it was arbitrary and capricious not to reinstate the pay.
So the Colonel has an obligation, in your view, then, to sort of make an adequate remedy for any violation of due process that occurs at the duty status hearing. And if he or she fails to, then that's reviewable in Superior Court.
Of due process, did you say?
Of due process at the duty status hearing, yes.
Well, the duties, Certainly, if there was a violation of due process that prejudiced the individual, sure, then that would be true. But in this case, the purpose of the Section 43 hearing is to expand the record, review the record, determine whether or not there was sufficient evidence there exists sufficient evidence to sustain a suspension without pay, and that's the substantive decision of the Duty Status Board. And if so, any procedural violation below would be harmless or would lack prejudice.
I have two questions, and they're not related, so I apologize. The first one is, there is some force to the trooper's argument that the timing of the suspension of the LTC suggests that this was a done deal. What's your response to that?
The suspension of the license to carry is completely unrelated to the.
Well, I know he has a separate remedy, but was his license to carry suspended as a result of the overtime scandal?
It was suspended, according to the letter suspending the license, it was suspended because of the letter opening the internal affairs of investigation into the fraud.
The overtime scandal.
That was also yes, and that letter was also the basis for the suspension without pay. But that can be those allegations were supported, and it can be the basis for the suspension without pay and independently the basis for the license to carry suspension. That does not mean that the employment status dictated what would happen to the license to carry. They're two separate decisions, two separate procedures.
But stemming from the same investigation.
The decision to open internal affairs investigation and the results of the audit demonstrating that there was sufficient evidence to support allegations of overtime fraud.
So my second question that's unrelated is, in this case, because of time, we know what the final decision was, and it comes out differently. How does that impact this case?
It has no impact on this case, Your Honor, because the question at this here before the court is whether or not the decision to suspend Adams without pay, that temporary suspension of his employment, whether that was supported by sufficient evidence on the record.
Even though ultimately the state police didn't prove their case?
No, because that could happen. And the question here is whether or not the state police couldn't know what was going to happen in the end at the beginning. The question here is whether or not the evidence that was presented at the time was sufficient to justify the decision to suspend him without pay.
I'm going to guess that Mr. Moynihan's going to say, yeah, well, the reason that they didn't know what was going to happen is because they didn't spend the time and give us the evidence and show us the records, and we would have been able to show, like that other trooper did, that the records were incorrect, at least in part, and that's ultimately what civil service found. So, well, it seems like it's unfair.
Well, they did have that opportunity at the Section 43 hearing. At the Section 43 hearing, after Adams had an opportunity to inspect, before the Section 43 hearing, Adams had an opportunity to inspect the underlying evidence and obtain the underlying evidence. That evidence was presented at the Section 43 hearing, and Adams did not provide evidence to rebut those pieces of evidence. So whatever was presented at the later hearings, I don't know, but before the colonel designate at the Section 43 hearing, there wasn't evidence to undermine these clear records that demonstrated the radio logs, et cetera, that provided sufficient support for these allegations that he wasn't working on the days that were alleged. And I'll add that before, just to go back to the duty status hearing, which you said he wasn't given the opportunity to inspect, Adams was given all the information he needed to rebut before the duty status hearing. He was given somewhere between 1.5 and 2 days, depending on where you look in the record, notice. He was given clear description of the allegations against him, a clear summary of the underlying evidence, including the dates they were alleging that he engaged in this alleged overtime fraud, and the factual basis for those, the radio logs, et cetera. Adams appeared at the hearing with counsel and had an opportunity to say to them, hey, on February 15th, I was working. That date is wrong. Could have provided evidence or could have just testified that, and did not. So there's very little, effectively what Adams is saying is that he was entitled to all of the underlying evidence that existed to support the allegations, more than just a summary of that evidence. And even in the context of a pre-termination, which requires greater due process than a pre-suspension, which is here, only a summary of the evidence against that individual is necessary. So he's alleging that there's a due process violation. He's arguing that greater process than even a pre-termination hearing is required here.
So the colonel has quite a bit of power. Included in that power, is there a possibility that this trooper can be awarded back pay by the colonel upon a determination that it's sort of like the analogy to kind of a wrongful conviction, that, okay, maybe there was enough to bring the charge, so to speak, to conduct the investigation and so forth, but ultimately if it pans out, it wasn't what we initially thought it was, but he's been harmed because he's gone without pay, and it's obviously very disruptive to someone's life and career. Does the colonel have the ability to restore to that individual what has been lost?
I am not sure. I don't have the answer for you on that precise question, but I would say that in this context here, we're talking about whether or not during the internal affairs of an investigation, whether or not there was sufficient evidence to suspend.
Yes, I understand that, and this is just sort of a separate question in my own mind, that I'm just trying to, if the trooper were unsuccessful here, I'm just wondering, is there an alternative route that can be taken through the administrative process with the colonel, because of the vast power that the colonel has, that in the interest of justice and morale of the individual trooper and other troopers, that, okay, if you've been sidelined, it's, you know, you haven't been sidelined with pay, you've been sidelined without pay, which is pretty devastating. Is there a way to get that trooper back on track so that you can get that pay back? I
would assume that process would have to be pursued through the case where he prevailed, the Civil Service Commission matter. I don't think that would come up here. Again, in this case, he was given a full and fair Section 43 hearing where he had an opportunity to rebut the allegations that were the basis of the internal affairs investigation. And at that stage, had he successfully done that or provided evidence to the Section 43, during the Section 43 hearing, demonstrating that he in fact did work those shifts, or that the records weren't, correct, or whatever it is, had he done that, he would have then, that would have been sufficient for the colonel to then, at that point, say, there was an error or whatever, there wasn't sufficient evidence, and at that point, that's when that decision about the back pay, I think, would have occurred.
All right, and back to the question on the license to carry. So we have the preliminary suspension with pay, and then there's the duty status hearing, but in the interim, the license to carry is suspended. And why is that done?
According to the notice of the license to carry suspension, it was done because of the allegations that underpin the internal affairs investigation, the allegations of overtime fraud. The same allegations that underpin the suspension without pay, but it was not revoked or suspended because he was going to be suspended without pay. The reason for the license to carry suspension, which the colonel has full authority to suspend independent of any employment decision, was that Watson letter, the letter that detailed the allegations against Adams.
But see, what troubles me about this too seems very disruptive to to a trooper because you're in a line of work where you don't make a lot of friends, and you're being disarmed. It's not just turning in your service weapon, but now you lose your license to carry, so you have to surrender all your firearms to somebody who has a license to carry. So I'm just wondering, what does that have to do with falsifying or being alleged to have falsified overtime sheets?
So, two things. One, he was on paid administrative leave at that point, so he wasn't out working. And second, that question is a separate appeal process, perhaps that goes through the district court and has a completely separate review. So perhaps what you're saying, maybe there isn't a sufficient nexus there, and if that's true, then that would have been appealed up through the other way. But the basis for that decision was the Watson letter and the opening of the internal affairs investigation, and not anything having to do with his employment status or the duty.
So anyone who has an internal affairs investigation opened, they lose their license to carry? Is that how it works?
I don't think that it's a blanket rule like that, but the colonel decided that the specifics of these allegations warranted, suspending the license to carry. And whether or not that was appropriate is a question for a completely different appeal and process that's separate from duty set.
Justice Toone has another question.
Just since now we're talking about the Civil Service Commission decision, is that decision final? Is it subject to appeal? Is it final?
I am not sure.
Okay. Assuming it's final, why is this appeal, and what difference does this appeal make in terms of anything? If the Civil Service Commission is ruled in Trooper Adams' favor, what does it matter if we affirm or reverse the decision of the Superior Court judge?
This decision, this should still be upheld, because the question before this court is whether or not there was sufficient evidence to sustain the suspension without pay for the duration of the internal affairs investigation. This limited suspension.
What practical difference does it make, though? That's my question. What practical difference would it make if we reversed or affirmed?
You'd be correcting the legal errors below, which were clear, and I don't know that Adams was. I'm not sure what the remedy was in that other case, so I'm not sure if he was given back pay. I understand.
Is this matter moot? Do you think it's moot?
I do not think it is moot, because the question of that limited period, the suspension without pay, that, unlike his termination, was proper. He was properly suspended without pay for that period of time while the internal affairs investigation was ongoing, because the evidence supported that decision. The evidence that was available at that time supported that decision. Adams failed to rebut any of the evidence that was underpinning that decision at the Section 43 hearing, so that was correct. He is not entitled to back pay for that period in this case. I'm not sure exactly what's going on in the other case, but that was a termination decision, and so that's different.
We will have to leave it there. Thank you. Attorney Moynihan.
Yes. May it please the court, good morning, Chief Justice Blake, Justice Hodgens, Justice Toone. My name is Daniel Moynihan on behalf of the appellee, Trooper John Adams. With me is my Associate Attorney Mark Russell. It's our position that the Superior Court decision of Judge Frison is a solid decision. There are 4 principal points to her decision. That John Adams was not—
Drive you crazy and
I'm sorry, Your Honor?
interrupt you for a minute. I saw you shaking your head, so I just have to ask. You don't think it's moot, right?
No, I don't.
Why?
Because, and I am thoroughly familiar with the underpinnings of this case because I was involved with it. I did not go to the Superior Court, but I was involved with everything before that point,
okay,
except for the actual duty status errors. But I can answer Justice Toone's question in the sense that we got a successful decision at the Civil Service Commission. He is back to work. He was terminated in July of 20. The Civil Service Commission awarded him back pay from July of 20 up until the date of their decision. So there's a period of time here from August 15 of 18 until July 20th, I believe it is, of 2020, where he was without pay.
So this period of time of what happened in this limited case, in this small window, he remains unpaid for?
23 months.
Okay. That's why it's not moot?
That's correct.
Okay, I'm sorry.
And as
Get
a
back to
matter
your original argument.
And I think it involves a very important issue on duty status hearings in general for state troopers. I've been involved representing troopers for 20 years, and we have a lot of history with these duty status hearings, and we have a lot of complaints about them. And I think it's important for a ruling from this court to affirm Judge Frizon's decision, which did have 4 principal points: that John Adams was not given a meaningful opportunity to be heard, to defend himself, or to present any evidence, and that the Section 43 decision was arbitrary, capricious, and not based on any substantial evidence. Third, that the decision of the Duty Status Board was arbitrary and capricious because it was only based on one piece of evidence, and that was the Watson letter with no attachments, and also that the Colonel's decision was based on an error of law. We, in our submission, have attacked the duty status hearing on 5 general points. Number 1, that the department violated its own regulations. And Justice Blake, I think it's a very important consideration here about the preliminaries before the hearing. We've mentioned, it's in the record, about news articles that very morning about the fact that the state police got many warnings on payroll abuse, and they did nothing. And that appeared in the Globe that morning. And coincidentally, earlier that morning at 5:15, John Adams' license to carry a weapon was suspended by 4 hours, 5 hours before the hearing. And to answer your question, Justice, in terms of a trooper cannot perform in a full-duty capacity if he does not have a firearm. So essentially, at 5:15 in the morning, we already knew that John Adams was not going to be working in a full-duty capacity. Somebody had made a decision at 5:15 or previous night that he wasn't going to be in the capacity of a full-duty trooper. And there are 4 options at a duty status hearing. They can leave him on full duty, they can put him on restricted duty, they can suspend him with pay, or they can suspend him without pay pursuant to Article 6.22 of the Department regulations. So we knew at 5:15, we had a decision he was not going to be on full duty, at least that.
So maybe you can answer the question. So if I can understand if you're suspended with pay, it would make sense that you surrender your firearm and your credentials. But why would the license to carry be suspended? Because, like I said, you may have personal firearms and that sort of thing for your own protection, so it affects that too. Is this a standard thing that happens, that if you're suspended with pay, that your license to carry is suspended as well?
Yes.
Wow, okay.
Yes, if you're suspended with pay, or suspended without pay, or if you're placed on restricted duty, your license to carry is suspended.
There was something in the record, though, and I'm trying to find it, and I can't find it off the tip of my fingers, about a concern about the way Trooper Adams interacted with somebody and suggesting that he was an explosive temper, separate and apart from the issue of the overtime scandal. That's somewhere in the record. I read it. Does that matter?
I don't think that was part of anyone's decision. Certainly not at the duty status hearing. Our argument, obviously, is that this was predetermined and that this hearing was a mere gesture, no due process provided, 5-minute hearing, 1 piece of paper, no attachments provided. We had this arbitrary decision by the Colonel pre-duty status hearing that if you have 5 irregularities or less, then we're not going to suspend you without pay. That was in the record. If it's more than 5, and John Adams had 6, you can be given the opportunity to try to disprove them. But here, we have 2 days' notice, we have 1 piece of paper, no attachments, no testimony, 5-minute hearing, no opportunity to be heard, no witnesses.
What difference does it make with respect to the statute that gives you Superior Court review, right? Let's assume for the moment that the trooper was denied due process before the Duty Status Board, but he was certainly allowed at the Section 43 hearing, allowed to examine the evidence, cross-examine witnesses, present his own witnesses, and that's what the statute allows him to appeal from to the Superior Court. Isn't what happened at the Duty Status Board sort of essentially water under the bridge by the time you get to the Section 43 hearing?
Well, let me say a few things to that, Justice. The actual duty status hearing happened approximately a year later.
Yeah.
The trial court properly reviewed the entire record, both duty status hearing and Section 43 record. We were given the opportunity to look at evidence. We filed discovery motions prior to the Section 43 hearing. We were given nothing. We were only given the opportunity to go for an hour and review documents at the headquarters under the watchful eye of legal counsel from the department. We weren't actually given discovery. It wasn't until we were able to go to the Civil Service Commission, we were able to do legitimate discovery, learn about the charges, and then rebut the charges in a favorable fashion.
Right, but that's not what the judge found there was a violation of due process at the duty status hearing. She didn't find there was a violation of due process with respect to the Section 43 hearing.
Right.
And again, that's what the statute says. You appeal from the colonel's decision following that hearing. So I guess I just don't understand. I think the Commonwealth's position is sort of, she focused on the wrong proceeding. What really matters is the proceeding where the colonel made the final decision. And you were allowed to present evidence. Now, maybe you didn't have all the discovery you wanted at that point, but that wasn't an issue that was kind of teed up for the judge in her review in this case. And good on you for finding more information and presenting to the Civil Service Commission, but with respect to review of the Section 43 hearing, it doesn't seem like there is a clear due process violation with respect to that proceeding.
Well, the Section 43 hearing is supposed to be a de novo hearing.
Yeah.
But when you look at Major Debuscher's language, it's clear he was not treating this as a de novo hearing. His specific language is, in his decision, that it appears that the duty status board, the board, properly based its decision to suspend Trooper Adams without pay upon Major Watson's request for a personal investigation letter, which was supported by substantial evidence. He's reviewing the duty status decision. He's not, in his language, in his decision, he's not making new findings. He's simply saying that the duty status board based its decision on substantial evidence. There was no evidence. We had one letter presented at that duty status. He also says that
were the overtime records submitted as evidence at the Section 43 hearing?
The pay station records were submitted, and forgive me, pay station records were submitted, and I believe payment records were submitted.
Trooper Adams presented his own evidence at that hearing, right?
I'm sorry, Your Honor?
Trooper Adams presented his own evidence at the hearing.
We did. We had Trooper Sullivan testify. I cross-examined Detective Ballou, and I cross-examined Attorney Brunelli.
Right. And I take your point about like the state police wouldn't suspend a trooper with 5 or less or fewer overtime regularities, but that's not a question as to whether or not the over-regularities in Trooper Adams' case actually occurred. It's just sort of an arbitrary cutoff as to how the state police decide to respond to this scandal,
arbitrary,
right?
Yeah.
Well, whatever. That was the cutoff line. So again, does that really go to the point of whether or not there wasn't sufficient evidence at the Section 43 hearing to sustain the colonel's decision?
Again, we're looking at that, and I would say no. But I would go back again to the point of this 12-month period between the duty status hearing, where his pay was taken away, his health insurance was taken away, and 5 hours before that, his license to carry was taken away. So this was a predetermined hearing where there was no due process provided, and we had 12 months go by where he was suspended without pay before Major Debuscher's Section 43 hearing. And again, if you look at the specific language of the Debuscher decision, he is hearkening back to the duty status hearing and telling us that they had substantial evidence and that they did not act arbitrarily and capriciously in suspending him.
Some of that delay, though, is attributable to, and rightfully so, some of the legal actions your client took to have other challenges adjudicated. So the fact that it took a year between the duty status hearing and the ultimate hearing, is that really an issue? I mean, obviously, the pay is,
right.
But you're not suggesting there was something untoward about that fact that it took a year.
No, not necessarily.
And to that, I just want to be crystal clear. You are not challenging the fact that generally a duty status hearing does not comport with due process. You're saying in this case, it did. I know you'd like the bigger picture, but here you're saying in this case, it did not comply.
Correct.
Okay, for the 4 points that you raised at the beginning.
Correct. And the fact, everything I've raised about it, and it's in the record in our brief, one letter, no testimony, not an adequate time to prepare. He's given nothing to defend himself against the charges. And in particular...
Let me ask you about that, because I think this, it seems to me the judge did make an error in that she seemed to be viewing the duty status hearing, which is really a preliminary hearing. She seemed to be viewing that as the main event, and really the main event didn't come until a year later, at which time then there had to be substantial grounds. But at this preliminary hearing, this duty status hearing, it's a pretty low standard. It's just reasonable grounds that the trooper is a subject of an internal investigation. That's all that had to be demonstrated. So the letter itself might be enough to carry the day there. It's not necessarily the time for digging into the merits of the underlying overtime issue. So, and just, but for example, bear with me for a second. If you have a trooper who gets involved in a domestic dispute and there's a 209A order that issues, you're going to have a duty status hearing. But you're not delving into the merits of what's behind the 209A order. The only issue is, did a 209A order issue
Correct.
relative to this trooper? And that's it. And that can be demonstrated very quickly,
Correct.
very summarily. So isn't that kind of what we have going on here?
I would say no, Justice. If you look at 6.2.6, it articulates the necessary ingredients for what they consider to be a due process hearing, and the state police violated it here. They did not present sufficient factual evidence, number one. Number two, to answer your question about the 209, if you look at that same article, there are specific provisions in it whereby they can suspend without pay, and one of them is a 209A order, that they can suspend without pay when there's a 209A order. They can also suspend without pay when there's a criminal investigation. That's automatic in their article. Also, you have General Laws, Chapter 30, Section 59, which allows municipalities and the state police to suspend without pay when there's an indictment. And I noticed Gilbert and Moore, the cases that were raised, very different. We have felony charges. Trooper Adams was never charged with a crime here. There was no 209A. There was no criminal investigation against him. He was never charged with a crime. We had a letter from Trooper Major Watson referencing irregularities, and that's all we had. So the judge below stated there was an error of law, and we believe that that is absolutely accurate in the sense that the state police violated their own regulation, and we articulate that in our brief. Other than that, if there aren't any other questions, Your Honors, I'll rest on our brief.
I don't see any. I want to thank both counsel. They were excellent briefs, excellent arguments, difficult issues, cases under advisement. Thank you all.
Nice job, Rebecca.
Our next case is James D. Javaris. I'm sorry if I've mispronounced that. Versus Stephen LaFortune, 24P322. And as counsel approaches, I just want to make sure, I know that Mr. Javaris is the appellant, but Mr. LaFortune is both appellee and cross-appellant. So is Mr. Hamilton going to argue 5 minutes first as the appellee, and then Mr. LaFortune 10 minutes as the cross-appellant? Is that how you're...
That is correct.
Did I get that right? All right, let me make sure my timekeeper is aware of that. So 5 and then 10? All right, she was ahead of me. She's a smart one. All right, Mr. Newmeyer, when you're ready.
Thank you, Your Honor. This is a very unusual case, but a very important case. I want to begin with the statute of limitations and the continuing representation doctrine established in Murphy. This is a key case because frequently things go wrong, and sometimes people want to blame the lawyer, but occasionally There's a mistake made in the Superior Court, and it's corrected by this court. Here, we had two judges, this is also unusual, reach different conclusions on the case, and the second judge didn't discuss the first judge's decision. I assert that under Parker versus Rosenthal, there must be actual knowledge of damages before the statute of limitations runs. Now, how does that apply in this case? Well, when I got in the case, and I only got in because of the fees that were being charged, I looked at it and I saw that there was a summary judgment motion that had been made. And I saw some affidavits indicating a lot of evidence of undue influence. And I get this decision of the appeals court, decision of the Superior Court that says there was no undue influence or any other claims. And when you look at that record, it should have been appealed, which I did. And when I get to this court, the court says, oh, we don't need to reach that. There was a second vote to remove Javaris because he took the money. And the fact that he paid the money back and gave a complete accounting that wasn't questioned and so forth was irrelevant according to this court. Now, that accounting had been given to the Superior Court, and they had it. There was no question that the other side had it. Nonetheless, the appeals court said we don't need to reach the undue influence claim. It was at that time that was causation and damages, and not before.
Well, let's just back up for a second. So you agree as a general proposition that there is a 3-year statute of limitation on legal malpractice, as a general proposition, right?
I agree with what?
As a general proposition, there's a 3-year statute on legal malpractice.
Absolutely.
So the question here is whether or not the continuing representation doctrine applies. And isn't the question then whether and when the client has actual knowledge that he suffered harm?
I agree that that's the question.
Okay, so then stay with me, because you know it far better than I do, so bear with me.
Right.
Why did the clock not start to run when your client asked Mr. LaFortune to withdraw? Isn't that when he knew he had a problem?
No, the record is very clear as to why counsel was changed, and that was the clearly excessive fees that were being charged. Hundreds of thousands of dollars were being charged, and here's the other irony, about fighting a right that Mr. LaFortune had been advised by Harvard Law Professor Sitkoff did not exist. That is, the right to use trust funds to fight your removal. But it was the clearly excessive fees that led to...
Well, let me ask you about that, because I'm thinking, I'm trying to put myself in the client's position. At what point do I suspect that my lawyer has steered me in the wrong direction? And that date, to me, goes back to March 2nd, 2017, when Judge Reardon issued the injunction, and he essentially said, you shouldn't have taken the trust money to defend yourself or to prosecute these claims.
Right.
And you got to put it back. So at that point, I'd say to myself, gee, it sounds like my lawyer gave me some poor advice here to take the money.
And that was correct.
So why doesn't the statute run at that point?
Because in addition to a mistake, you need causation and you need damages. Now, Judge Reardon also heard the summary judgment motion and wrote this opinion, and he made nothing about taking, it made no mention about taking the money as being a ground for dismissal. And the only time that damages were known to Javaris was when he got the appeals court decision. Because the appeals court decision said, we don't need to reach this undue influence. There was a second vote taken, and you lose, and it doesn't make any difference that he paid all the money back, gave a complete accounting, and that was completely satisfactory. He could have asked for interest on the money. He didn't want to ask for interest on the money. They weren't interested in that. They just wanted to get rid of it.
Yes, but my point is, why isn't the the essence of the malpractice here, and there could be several different points of malpractice, but the one I'm focused on is the one that happened pretty early on, and that was March 2nd, 2017, which would mean that the statute of limitations ran well before the complaint was filed. Why is it that that is not the operative date here? Because at that point, the client is aware, fully aware, that the advice given by the lawyer was incorrect, so said a Superior Court judge.
I agree with that. The thing which is missing is causation and damages.
Do you really
Because-
need like all the elements of a claim, or do you need to be on notice that you received bad advice?
Well, you can get bad advice, but if you want to recover damages, you have to have damages. In this case, Judge Reardon was unimpressed with the argument that was made below about we're outraged because he took the money. He knew all the money had been paid back. He'd been given a complete accounting and so forth. And he ruled as a matter of law that there was no evidence of undue influence in the case. He also made some other rulings. Now, we can't have a system that makes any sense if a lawyer makes a mistake and doesn't cause any damages, and then the lawyer is sued. We need a system whereby if a mistake is made, but it doesn't cause any damages, lawyers make mistakes every day. Lawyers make mistakes every day.
The damages are coming. They just need to play themselves out a little bit to get finality. The damages are, the prospect of damages are pretty evident at that point, but
No,
I see you're saying, well, it's not really, well, let me finish. It doesn't really
please.
matter until this court rules. But a different problem with your argument is that the continuing representation doctrine only tolls the statute of limitations so long as the attorney in question continues to represent the plaintiff's interests in the matter in question. And that indisputably stopped in November 2017.
That's correct. Yeah.
So why doesn't that itself mean that this is untimely?
Because at that point, we had a decision of the Superior Court that said as a matter of law, there was no undue influence, despite the affidavits in the case that indicated to the contrary. Now, in that situation, we want a procedure. It makes sense to have a procedure to have an appeal to see whether that's correct. This court didn't say that that was correct. This court said, we don't have to reach that question.
Right, but I'm just sort of saying
And-
you can't rely on the continuing representation doctrine if the attorney is no longer representing you. The tolling stops at that point, and that's more than 3 years.
I agree completely with that.
Okay, so what gets you to the next? What gets you?
But I do need to have a damage claim. Sometimes lawyers make mistakes. Lawyers make mistakes all the time. But they don't cause damages.
Well, the standard isn't damage. The standard is appreciable harm.
I'll accept appreciable harm as a. But if I am hiring somebody to buy a house, and for some reason I get a deed that's incorrect, and I don't find out about that for years, and I'm not causing any damages for the years, I don't believe the statute of limitations should run until I have damages caused by the negligence. And in this case, the Superior Court, it got the same argument that was made here. Oh, he took the money, we're outraged, and so forth.
Yeah, but it's deeper than that, though, because we're not just dealing with the man on the street. The client was a trustee.
Right.
So he was in a very special position. And now it's looking to the beneficiaries like the trustee has his hand in the cookie jar. So how do you ever recover from that with the beneficiaries? Isn't there appreciable harm right there at that point that a judge has said you took money from the beneficiaries and you got to pay it back?
And he did pay it back, and he gave a complete account.
But how do you?
And that was not questioned.
Isn't there harm there? Isn't there irreparable harm? The relationship between the trustee and the beneficiaries. How do you ever recover from that?
Well, at that point, he'd been removed, so he's not. He'd been removed, so. There was a new trustee, so we didn't have to worry about that. But we do need a system. Lawyers and doctors make mistakes all the time. And it's not till, and I think
Can I just ask you, what is, you keep saying that, and I appreciate the argument. What is your best case for that proposition? What case says what you're saying?
I would say my best case is, you've got so many good cases here.
Just give me
Probably Parr versus Rosenthal, that there has to be actual knowledge of damages.
Well, actual knowledge I understand, but you're also saying there has to be actual damages. Is there a case that says that for purposes of the statute of limitations?
I just have been doing defense work mainly for years. I mean, if you don't have any damages, you can't recover anything. I mean,
That's true at the end, but I'm back at the beginning because we're looking at statute of limitations. So do we have a case that says the statute of limitations is told until you have actual damages? 'Cause that's what I think you're arguing.
Plaintiffs' lawyers can't recover anything if they have a negligent act and they don't have damages. I mean, that's just it's just not done. I mean, I've done mostly defense work, and you do need to have some damages. And here we don't have any damages is the problem until the appeals court renders its decision saying you lost it because there was a second vote taken. You took the money, and it doesn't make any difference that you paid it back and gave a complete accounting. That's just.
And why is it that damages didn't arise until that point? What were the damages at that point?
If suit had been brought earlier, the defense would have been, quite correctly, you had the affidavits in the file, and you had a decision by Judge Reardon saying there was no undue influence as a matter of law. In the teeth of the affidavits, which are quoted at some length, I copied them actually from LaFortune, as to what those affidavits said as to how the grandmother was treated. And you didn't appeal that? We don't want a system where a lawyer makes a mistake, there's no evidence of causation of damages, and the lawyer is sued. We want a system where we exhaust our remedies, and it's only after those are exhausted that it's clear that damages were caused by the lawyer. Lawyers make mistakes all the time.
Okay, but I'm just going back to your point.
Rosenthal is my...
Your point, June 9th, 2020 was when the appeals court affirmed that decision. And you had indicated that it was at that point that the client would be aware of not just a mistake by the lawyer, but damages by the lawyer.
That's
so
right.
I'm asking you, what are the damages at that point in time that the client was now aware of that he was not aware of before then?
Well, they were aware that the lawyer had made a mistake, which had caused the loss of the case. And that's the damages. As I said, Parr versus Rosenthal, which I should have said, is actually a med-mal case. But doctors are like lawyers. They make mistakes all the time. But you have to have causation and damages before the statute begins to run, if this system is going to make any sense. And that is, that's just a very important fact. Now, I also say that somehow, with respect to the statute of limitations, we do have the Shaw supermarket case. And if the continuing representation doctrine somehow is going to be modified by this court or found to be inapplicable by this court must apply the Shaws versus supermarket, which is, I don't cite it, but it has been applied in many appeals court unpublished cases. And that's just the law of the land. I see that got 29 seconds. Are there any questions on the excessive fees or?
I don't see any questions from the panel. We're happy to take the rest of your argument on your briefs.
Okay, I just want to mention one thing. He did spend all this time in December. It was all about fighting about a right he knew did not exist, the right to use trust funds to litigate the claim. And he had gotten the Sitkoff report and just said, I'm not paying attention.
Thank you, sir. Mr. Hamilton for 5 minutes.
Chief Justice Blake, Justice Hodgens, and Justice Toone. May it please the court, my name is Terrence Hamilton, and I represent Stephen LaFortune as he is the defendant appellee in this case. And I am representing him strictly on the legal malpractice claim. And we are here today to ask the court to affirm the judgment of the Superior Court. The decision of the Superior Court, which appears at page 66 in the addendum to our brief, is a very straightforward opinion based on both the facts and, most importantly, the law, which the justices have already spoken about in this particular case.
So what's the operative date for purposes of the statute of limitations, in your view?
I'm sorry, the continuing?
The operative date for the statute of limitations, even if we were to assume continuing doctrine applied?
Well, the statute of limitations begins to run, or the cause of action accrues, when the client recognizes that he has been appreciably harmed by his client's, by the lawyer's conduct. And in this particular case, it occurred very early on. It occurred perhaps as early as 2016, when Attorney LaFortune and Jim Javaris had some differences of opinion as to the trustee fees and whether the trustee could take fees from the trust itself. And Attorney LaFortune's advice at that point was, no, you can't do that. You have to be able to get a bond. The more appreciable harm, and it's not always actual knowledge, although in this particular case it eventually became actual knowledge, and that actual knowledge occurred, as I believe Justice Hodgson pointed out, on March 2nd, 2017, when Justice Reardon issued his decision on the preliminary injunction. And just let me read very briefly, right in the plaintiff's complaint, paragraph 21 of the complaint, he points out the order of Justice Reardon on March 2nd. And the complaint in paragraph 21 goes on to say, essentially every aspect of the court's order was contrary to what Alexandrov and LaFortune had counseled Javaris would happen at the outset of the action. That, Justices, I believe, is actual knowledge, although, again, in this particular case, there were many instances, numerous occurrences of this appreciable harm. And
do you need damages at that time? Do you need to know what your actual damages are?
Absolutely not, Your Honor. The cases have been very consistent in terms of indicating that a client need not know each and every element of a cause of action, doesn't even need to know that it's legal malpractice, so to speak. We're talking about laymen, although in this particular case, we're obviously talking about a very well-educated businessman who had constant contact with Attorney LaFortune, as you can well tell by the documents that came out during the counterclaim. So that in this particular case, the Superior Court judge chose the simplest and the most obvious occurrence to say, at the latest, the client knew as of November 10th, 2017, when the client asked Attorney LaFortune to withdraw, that started the statute of limitations. And the continuing representation doctrine does not apply because in order to have continuing representation, you need to have representation. The representation disappeared. And finally, even if the continuing representation doctrine could have been applied in this particular case, if it had not quite been 3 years, there was no innocent reliance in this case. And without innocent reliance, you cannot the continuing
time
representation
is up.
doctrine does not apply.
Let me just check. Okay, we're going to have to leave it there since we're
Understood.
splitting our time.
Thank you, Your Honor.
Attorney Hamilton. Attorney LaFortune, and you're going to be arguing as cross-appellant.
Good morning. Attorney Stephen LaFortune, appearing pro se on his counterclaims. I've stated my entire case on the counterclaims in the briefs. There's nothing to add. Judge Wren held a 2-day trial, assessed the credibility of the witnesses, found my fees were reasonable. When I cross-examined Mr. Javaris as to what facts he had as to my fees being clearly excessive, he said he couldn't provide anything. They provided no other evidence. I've asked him in depositions. I've asked him in interrogatories, and depositions aren't in the record, but the interrogatories, my testimony are in the record. They provided no evidence as to how my fees are clearly excessive. Judge Wren has discretion, and he can't be overturned unless his decision was clearly erroneous, and I saw nothing in the briefs, as I put in my reply brief, where they've even addressed the clearly erroneous standard. The one error that I do believe Judge Wren made was on the 93A claim. At trial, and there's exhibits in the record, at trial, Mr. Javaris admitted that he led me on by saying that a client owed him $190,000, and that when he received this in early January of 2017, he would pay me. At trial, he admitted that he fabricated the story, so I continued to work for free at that particular point in time. When I kept on pressing him, where's this money, he claimed that $40,000 came from this fictitious client. He then turned to the ruse that he was flat broke. There's a text message or email from Attorney Alexanderoff copied to Mr. Javaris, where he confirms all the statements of Mr. Javaris that he was flat broke. As it turned out, when I deposed him and at trial, he admitted that was false also.
I mean, you'd agree that, that's not uncommon for, my gosh, someone's in the midst of litigation, a lot of money at stake, his reputation is at stake. Apparently he had a stellar reputation before this, made a ton of money for this family, saved him from financial ruin back in the 1990s, and now it's all on the line, and he's trying to scrape enough money together to defend himself here and defend his reputation. And isn't it understandable for someone to say, yeah, I'm going to get you the money, I'm expecting a check from somebody, it's going to be coming in, it's going to be substantial, and then it just doesn't work out. Those things, that doesn't mean that it's unfair and deceptive.
Well, it does if that client never existed and the money coming in never existed, and then he had the ability to pay. Well, that's what he admitted at trial. I have clients promise me all the time to pay me. I understand that, and I understand they're in a lot of stress. But you don't make up a fictitious client that allegedly owes them $190,000, none of which was true. That's unfair.
But it still boils down to kind of just a non-payment of a contractual obligation, right? And the law is very clear. You need more to elevate a breach of contract to a 93A violation. You need some sort of attempt at leveraging some other result here. And so I'm not sure I see that based on the fact that he may have made a misrepresentation to you in terms of non-payment. What is there that he kind of leveraged his violation of the contract into something else to sort of gain some other advantage from
I did cite a 93A case that's stringing along somebody to pay falsely.
Stringing along for some other purpose. Stringing along itself is not a 93A.
Well, stringing along so that I would work for free and not pay me when you're promising to pay me, and both of his attorneys outside attorneys are promising to pay me. This client never existed. He admitted it. And then he also used the ruse, and some clients do this, that he was flat broke. And this is a paper documentary trail. And he admits, no, he was very successful. He had the ability to pay the fees. Those are outright misrepresentations. And it goes along more than just stringing somebody along.
Judge Wren wasn't moved by any of that. So are you saying that we're in a position that we can disagree with what Judge Wren found?
Correct. Yeah, given the facts, it's a written paper trail in his admissions. I cited a case where it's de novo review by this court, whether the misrepresentation of this fictitious client, and it wasn't just somebody who did, an immediate outburst. He carried the ruse through emails. I got $40,000 from this client, I'll give it to you. He carried it along, and when after a period of time that didn't work, he then resorted to, I'm flat broke, I can't pay you. I'll pay you $10,000 a month, and he made all kinds of promises, and he didn't do it. It goes beyond client, and I had known him, and if he had sat down and been truthful with me, it might have been a different result, but you can't make those types of misrepresentations. And it goes beyond stringing along somebody, they're blatantly false. And I cited that case in my brief, where given these facts are undisputed, you have a de novo review of whether that constitutes a 93A. And that's this court's decision. I mean, the amount of money I had to put out of my pocket, paying associates, working all kinds of hours, not being able to work in other cases, I'm trying to save him from these people who are accusing him of stealing millions of dollars from the trust. And had sued him in the insurance fraud case that Mark Geronimo had. And in an October 15th letter, were threatening to sue him again. And so by the time I had got done with the global mediation, we were clear to resolving this insurance fraud case, and he had put them on the defensive. While I'm doing all this work and promising, again, he had two outside attorneys, Attorney Alexandrov and Attorney Bevenzi, who were promising me I would get paid, who had reviewed all the bills, had found them to be reasonable and said, don't worry, you'll get paid. And Attorney Alexandrov, in one text message email, apologized to me, saying, I didn't know he had such poor financial problems. Well, he didn't. He admitted at trial that he never had these financial problems. So it's up to the court to determine on a de novo review whether that rises to the level of 93A. It was, given the amount of time that I was putting in and doing all this work, and he had the ability to pay, and I was encouraging him to get other counsel, but Attorney Bevenzi wanted me to stay on. It's in the record, the trial record. He should have paid. He shouldn't have misled me that this client was going to pay him, and he shouldn't have misled me that he was flat broke when he was extremely successful making, it's in the record, $2 million a year, he originally told me. And then he originally told me that was not true, that he was flat broke, that he had sold his BMW. These are the things that he was telling me to string me along. And this isn't just somebody who didn't have the ability to get another attorney. He had his brother-in-law, Attorney Neumeier, and he had Attorney Bevenzi, who does litigation work, who had been his friend for 30 years. I was asking Attorney Bevenzi, why don't you represent him? It clearly had listened to my advice from the beginning, including not being able to even do any discovery in this case. The record's pretty clear, and unfortunately, as Attorney Hamlin put out, there's a large paper trail with regard to this case. So it's not my word against him, and he's admitted a lot of this stuff. And their response in their brief was, well, because it involves a legal fee, it doesn't constitute 93A. It was outright fraud for him to tell me that type of stuff and having me take constant money out of my pocket to pay my associates my overhead, and I've had plenty of work to do on other cases. Not fair to me.
I don't see any other questions. We're happy to take the rest of the argument on the briefs and the SORB reply briefs that have been filed. So thank you.
Thank you.
Case is under advisement. You cannot, we do not permit rebuttal in the appeals court. Thank you so much.
Thank you.
Case is under advisement. Our last case of the morning is, or afternoon, I'm sorry, is Kathleen Bellarado versus Pilgrim Insurance Company and another. Docket 24P575.
Good morning again.
Switching tables, I guess.
Yeah, I've been busy. Attorney Stephen LaFortune, and I represent the appellant, Kathleen Bellarado. 3 issues in this case, and I put them all in my brief. The first issue is whether the insurance company has to put their insurance exclusions as an affirmative defense. Every other state says yes.
What does Massachusetts say?
Well, Massachusetts, there's a lot of cases that imply you have to do that because the appeals court or the SJC would say the insurance company raises this as an affirmative defense. I couldn't find an exact case that says you have to do that, but the purpose of an affirmative defense is put me on notice of what you're going to say as a defense, so I can do discovery or I can prepare for that. As I put in my brief, they didn't raise any exclusionary insurance as an affirmative defense. And I also know the Superior Court didn't cite any cases saying you don't have to provide an insurance.
Oh, go ahead. Finish.
No, let's go ahead. You're the judge.
So, right, there isn't any case in Massachusetts that says, there are some cases that refer to exclusions in terms of affirmative defenses, but there's no case, as far as I've been able to see, that says you have to plead it as an affirmative defense. And it's a little complicated, right, because we have this burden-shifting framework where the insured has to make an initial showing coverage, then the burden shifts to the insurer to establish, to prove any exclusion, right? So it's not clear how that matches up with the requirement that an exclusion be affirmatively pled. But in any event, even if we assume that was the rule, the standard, isn't it, that whether or not you received adequate notice of the exclusion, right?
No, there's no case law, and the case law that I cited was, again, from other jurisdictions saying even if I received notice, it still has to be pled as an affirmative defense. And I cited many cases saying that defense has to be pled in the pleading as an answer.
Right.
Correspondence is not
there's
right.
many cases where even if there was a failure to plead an affirmative defense that's actually listed in Rule 8, still the ultimate question comes down to whether or not adequate notice was given to the claimant.
It's true. And no.
So I want to focus on that. So you say you weren't given adequate notice of this defense. Wasn't the initial denial letter by Liberty essentially saying that Cunningham didn't drive this car? Cunningham didn't drive a car that was covered by insurance?
Well, there's a disputed issue there as to I put an affidavit and I never got that initial letter. So that was in the Superior Court record. The first time that I received notice that Liberty Mutual was going to raise this defense was in the summary judgment pleadings, and they used the business exclusion defense. When that argument didn't go well at oral argument, they then put in a supplemental memorandum using the regular exclusion.
Their initial summary judgment motion identified the regular use
exclusion. But it didn't really argue out the issue. It identified.
It cited the language. You didn't respond to it in your initial opposition. Then there was a hearing, we don't have the transcript of, but I assume that issue was raised at the hearing, and then you were allowed to file a supplemental memorandum where you addressed the regular use exclusion at that point.
That's correct. Okay. Well, that was the judge's opinion that it hadn't been adequately addressed. So he allowed the parties to file supplemental memorandum at that particular point in time.
Okay.
So that's the first time. If you look at the letter just before that, a few weeks before that pretrial hearing, Liberty Mutual said they were only raising the business risk exclusion. They never said they were raising the regular use exclusion.
In your correspondence with Liberty's counsel, that's correct.
That's correct.
In their initial summary judgment filing, they specifically cited the regular use exclusion.
Well, I guess the extent of it, I guess it speaks for itself, but the judge didn't feel like they adequately addressed it.
Okay.
So that's why he allowed supplemental memorandum to address it.
Okay.
It didn't go well on the business risk exclusion. So, based on the Beecher case. So the notice wasn't until, you can't even call it the midnight hour. And
was there any discovery that you would have wanted to have taken on the defense that you didn't have in terms of, even when you responded in your supplemental memorandum, were there any facts that you wish you had been able to develop to sort of oppose the defense?
I put that in my brief because what they do is they cite Mr. Cunningham's deposition. The problem was his deposition was taken in the underlying case, and nobody had, including me, had notice of what their defenses were going to be. So,
Well, wait a minute, though, but, I mean, if you go back to the answer, I mean, the Liberty's answer it's pretty clear, I think, as you read it, as to count 1, paragraph 16 through 23, Liberty repeatedly says the defendant, Liberty Mutual, denies the allegations against it, and this is as to the 93A. And then when you read that in conjunction with the affirmative defenses, and there is one of them that says, the complaint fails to state a claim against the defendant, Liberty Mutual Insurance Company, upon which relief can be granted. That, in conjunction with the correspondence, it seems pretty clear to me that Liberty's saying, we don't insure you.
they did do that, but they didn't.
Isn't that enough?
No,
They're saying that.
No, if you look at all the case law from the other jurisdictions, and the reason is, I have to be on notice of what they're raising in that insurance agreement, so I can take discovery on that issue. And it's their obligation. Massachusetts would be the only jurisdiction where you don't have to specifically say, I'm relying on this specific exclusion. There's cases from other jurisdictions that state, you can't just say the insurance policy doesn't cover it, or the exclusions don't cover it. You have to provide notice of what that defense is. And they didn't know that. I mean, it's pretty clear if you look at the history. And again, the first correspondence that I denied getting, and I put an affidavit in that effect. But if you look at the history of it, they didn't even know what exclusion they were relying on, because they specifically say, when I am corresponding with Liberty Mutual's counsel, we're using the business risk exclusion. And that didn't work out for them. So they didn't know what exclusion they were using at that particular point in time. And they were required to specifically tell me what exclusion they were using, so I could have gone and gotten discovery from Mr. Cunningham on that issue.
But you took his deposition in the underlying matter, right?
That's correct.
And a lot of questions were asked about the circumstances under which he used this particular truck, right? And he said, I typically used it. I used it to, personal and business uses. I used it to commute from work on this day. A lot of evidence was developed on the applicability of the exclusion. What else would you have asked him?
Well, what does typical mean? I mean, let me give you an example. I rented a car when I was on vacation with my daughter a couple of weeks ago. I typically rent a car. He doesn't say what the circumstances were if he was going to a job. It has to be regular, continuous use. And I did cite a California case, unfortunately, it's no Massachusetts case, that commuting to and from work does not constitute the regular use exclusion.
Yeah, but Galvin, we said using a work vehicle for commuting is covered, right? It is subject to the regular use exclusion. That was a trooper who was using the pool of cruisers provided by his workplace. Doesn't that kind of cover the situation? Mr. Cunningham was using the car owned by his parents' company?
He was using the vehicle to commute. Well, we don't know. He says he used it sometimes to commute to work. He says it was typical use of the car. We don't know what the circumstances were of that use, whether he was just using it to go to a job or, typical is a very vague, broad word. I mean, under what circumstances? I mean, if the other car wasn't available, then was it typical? I would have liked to question him more on that particular issue. But again, it's not my burden to prove that defense. It's Liberty Mutual's burden. They have to.
Right. Well, under the summary judgment rules, right, you have the opportunity to file a Rule 56F affidavit that asks for more discovery before the court rules on the summary judgment motion. Did you do that here?
There's so many I typically know, and I don't believe I did on that particular issue. Again, it's not my burden of proof. It's the Liberty Mutual's burden of proof to prove that defense.
Sure, but as a party responding to a summary judgment motion, you have to respond to the facts they put into evidence. And so that's typically the procedural mechanism that you use to sort of say, I need more discovery here before I can respond.
Well, I made the argument that was vague, and that I think Superior Court ran with it too much, saying that he assumed that I received notice when I didn't receive notice. And he made these subjective conclusions or speculative conclusions that there was regular use. Typical use isn't regular use. It has to be, if you look at the standard, it has to be continued regular use of the vehicle. People borrow vehicles all the time, and I just gave you the example of renting a vehicle. Typical. If I go on vacation, it's typical I'm going to rent it from that particular agency. It's just unfortunate that Liberty Mutual waited that long to raise that defense and have the burden of it, and we're making assumptions as to what Mr. Cunningham meant by the word typical. It's not a weighing of fact at that stage. All the inferences should go in my favor. Maybe it's something typical, something that should be done more at trial, where you deal with the evidence you're dealing with. And that's why you need notice of the particular exclusion. And giving me the business risk exclusion is entirely different from the regular use exclusion. And it was, I would contend, and of course it's up to this court, that it was required that they were to plead that affirmative defense. And there's numerous cases saying you can't just give notice later. You have to do that in the answer of that particular insurance exclusion and be specific on that, what exclusion you're raising. There's a broad list of exclusions, not for me to speculate and guess. It's for them, and I'm not going to prove their case. It's for them to raise that issue in the answer.
Don't see any additional questions. We're happy to take the rest of the argument on the brief if you'd like.
Yes, Your Honor. Thank you.
Wonderful. Attorney Stoltz.
May it please the Court. Lindsay Stoltz from Nelson Mullins on behalf of Liberty Mutual. Your Honors, appellant's claims clearly rise and fall on whether there was coverage under the Liberty Mutual policy. And it's our position that this is a case that Liberty Mutual should never have been involved in. From day one, it denied coverage, and it went correctly and continuously throughout the entirety of this case.
What's your response to the claim that Bellarado's counsel didn't receive that letter?
I would point, Your Honors, to the record, which includes both the claim notes and the actual letter. That shows that the Liberty Mutual adjuster left a phone voicemail. I believe it was in November of 2019, the same date that that letter is dated. There's another note a couple months later in which the same message was sent to counsel. So I think there's multiple instances on the record that shows that Liberty Mutual diligently investigated and communicated its position.
Okay.
And with respect to the undisputed facts here, and I think they're important, as Your Honor noted, Mr. Cunningham was driving a Ford Edge on the day of the accident. That Ford Edge was not listed on the Liberty Mutual policy, his personal auto policy, which listed 2 other vehicles. That Ford Edge was owned by Cunningham Machine, his family's company, and it's undisputed that he testified under oath that he typically drove that vehicle. It's undisputed that he drove it to and from work, and on the date of the loss, he was driving it home from work. Again, Liberty Mutual diligently investigated, relayed its position. The only real controversy here, I would say, is just this one small policy provision, right? It's Section 5, the optional bodily injury provision, which,
I guess
we can
get into the core issue, which I think is, why didn't Liberty identify that exclusion in its answer?
I mean, I can't.
The answer is very generic.
Right.
It's sort of, we deny, but doesn't really say anything, right? And the point is to sort of make your position clear. You kind of seem to have done that in the earlier letter, though you didn't actually cite the actual regular use exclusion. Why not, work up the issue and put it into your pleading so that everybody knows what we're dealing with here? And I think it's compounded by the fact that in subsequent correspondence between Liberty's counsel and plaintiff's counsel, they identify a different exclusion that's actually not applicable, the business risk exclusion. So that makes the case even more complicated, right?
No, and that's a fair question. I think there's a number of factors. I think that there was confusion on the side of Liberty as to why we were even receiving certain correspondence or whether it was directed, because there was instances and references to the Pilgrim policy in the first place. With respect to answer your question directly, yeah, would it be ideal to list every single exclusion that could apply? Absolutely. But I believe here there's sufficient notice that this is the position of Liberty Mutual. particularly here in an instance in which this is the type of exclusion that requires discovery, right? And so we presumably won't know until the discovery happens as to which exclusions may in fact apply. We don't know what a third party does or does not with respect to a vehicle that's involved in the accident that's not on Liberty Mutual's own policy. So there's a number of factors here. And I think, and I don't know that, and skipping to the notice issue again, Rule C, there's nothing in Rule 8C that states that this needs to be, this express provision needs to be included, asserted as an affirmative defense. There's no case law that says that we need to list this express
I mean, there are cases,
Yes.
your brother's correct, that there are cases in other jurisdictions that say that. We haven't ruled that in Massachusetts. But it's certainly, whether or not it's a rule or not, it seems to be a much better practice than raising the exclusion for the first time in your summary judgment motion.
Understood.
Right?
Even
Certainly because we're supposed to have already done the discovery before the summary judgment gets filed, right?
That's a fair point. I would say even assuming that's the case, skip ahead to all of the case law. If we're going to go to any sort of extra jurisdictional case law, and I know at least the First Circuit's, that it's not fatal to not list the exclusion as an affirmative defense under two circumstances. One, as long as there's no undue prejudice, and two, if it's the sort of fact that we wouldn't even know at the time that the answer is filed. So I think even assuming that you know, Massachusetts jumps on board and says that specific exclusions need to be asserted, that two-part exception, it's an or test, certainly does apply, and those facts would apply here.
That's a great point. How does Liberty Mutual know when this lawsuit is filed that the driver of the vehicle is regularly using the other vehicle? You wouldn't know that.
Correct. Here we have the benefit of an underlying suit that was filed earlier and testimony under oath of that, but you imagine a scenario where different facts and different circumstances and different timings of filings where it compounds the issue and leads to a scenario where we're moving to amend multiple times throughout
So
the
that
case.
makes sense so the parts of the answer that I read are consistent with that because they're just sort of general denials and that's based on Liberty's review of the policy, and it's two other vehicles not in any way connected with this incident, so what else can they put in the answer but that?
Indeed. And I'll note that this is a policy that's, you know, word for word, pretty much identical to that drafted by the Division of Insurance. So it's not some unknown exclusion that's out there that's specific to this policy or an amendment to that policy. This is not a surprise in that sense.
Still, you would agree, as a general practice for an insured Massachusetts, you want to give parties as much notice of the basis for your denial of coverage as possible, as soon as possible, right? So that everyone has a fair chance to kind of work these issues through.
Agreed. I don't disagree with that. I do take issue with my brother's position with respect that there was no notice at summary judgment, and some of the representations as to how this played out. I'd point this court to Record Appendix page 36, 38, 45, and 255, in which we clearly and expressly referenced that exclusion with respect to the, and I know you don't have it before you, but the issue was not raised in response to the opposition brief, and the trial judge allowed further briefing for the sole issue as to what typical meant. And as we put in our supplemental brief, typical is dictionary synonymous of regular. So that in terms of background is why there was supplemental briefing at the request of my brother here. If there are no other questions, I am happy to rest on the brief.
I don't see any. Thank you so much. The case is under advisement. That will conclude today's session of the Appeals Court. I'd like to thank the court staff, our court officers, and our fantastic timekeeper. Thank you very much. We are in recess.
All right.